Good morning, good morning, good morning. How's everybody enjoying the SRC Summit so far? I think it's a wonderful, wonderful conference that the industry absolutely needs. We need more education without fail. If you're an association and you want to see things change, I keep hearing and I seeing people posting on Facebook about the associations. If the association is not pushing education as the number one goal, then I'd start to talk to them about it. The only way that will change is if you, the user, whether you be a public adjuster, a restoration, it doesn't matter where you're at, an attorney, we should be mandating education inside of these associations. You don't know how to fill out a proper proof of loss? Well, then let's teach you how to fill out a proper proof of loss. You don't understand what the process is? Then dadgummit, let's teach you what the process is. Now, I see many graduates in here. There's quite a few graduates in here, and there's people that I've never seen in here before. The graduates know for sure that that's what we teach, that's what we preach, and that's what we live in our own life. You have many influencers that come up and they get on here and they profess to tell you things, and they're not actually practitioners of what they're talking about. They haven't actually put in the work and done the years. Shaun, between him, Melanie, and I, we've got roughly 55 or 60 years combined in this space at a very high level. We take every claim to the fullest. We sign an agreement with the insured in the very beginning that agrees with them and that we're going to take the claim on one condition. If we take it, we're going to see it through to the end. Right? My name is on that claim. The company that we have built, the relationship that we have with the insurance companies, whether it be good or bad, is our reputation. And we don't have a bad, good morning, young lady, come on in and have a seat. My lovely wife, Melanie. The relationship is how they choose it. It's not something that we get to choose. We do our job, and if you like the job or if you don't like the job is not within my control. So I'm not really concerned whether you like me. I'm concerned whether I did a good job and I performed the duties after a loss and I completed everything that the insurance company contract required between the insured and the insurance company. Once that's done, then it's up to the insurance company to decide how they want to act. No different than you. When you leave here and you get on 635 and it ain't you, but you and 4 other cars out there, you can choose to do the speed limit or you can make a choice like Cal does. We're going to run as fast as this thing will run. Why? Because I have a wide open space and I have the ability to do so, but I do that with one thing in mind. If I get pulled over, it's my own damn fault. I knew what I was supposed to be doing. I knew I was not supposed to be speeding, and I made a conscious decision to break that rule because I wanted to speed a little bit. It is the same with the carriers. They don't have an option. The problem is that we're not educating, and then we're not educating properly. The contract is not near as confusing as everybody thinks it is, and everybody that's been to the camp can attest to that. Contract's real simple. We make it gray. They make it gray. They make it gray because it's very profitable for them. We make it gray because we're not obtaining the education to discern what is gray, what is black, and what is white. The contract and the statute tells us clearly which ones are which. The we pay section of the policy, how many of you are familiar with that section? Okay, so the we pay section is very clear. It is when the insurance company has set out the conditions under the policy and the insured has met those conditions. Do you know when you talk about the we pay section other than that? You don't. It now becomes the gimme section. The insurance gives you anything that they want to give you, and you have no right or authority to say anything different because you didn't follow the rules. In other words, you will never see the we pay section of the policy where you force the insurance company to make a decision unless you perform those duties after a loss. Okay, so when we get to the we pay, how many of you, ex-students excluded, how many of you are submitting SPOLs on every claim that you perform? You're a student. And you're submitting them? And you're not a student, right? Okay, and what prompted you to submit SPOLs?
I worked for the insurance carriers before.
And they had you submit SPOLs?
No, but I know what I was looking for at the time, that I wasn't going to issue payments, so I was.
It's and we teach a lot of people, it's very odd to have somebody make that statement, especially when they come from the insurance carrier side, because it's their kryptonite. If you don't want to know what a carrier's kryptonite, it's that damn SPOL. That's why they try to hide it, get it out of sight, because it triggers everything. To the We Pay section, what is the first requirement on the We Pay section for the insurance company to actually be under the contractual obligation to pay you? What is the very first requirement? We received your SPOL. You understand what I'm saying to you? If you haven't submitted an SPOL, you have not triggered factually. Not only have you not abided by the duties after a loss, but you have not set the very first trigger that makes the insurance company get off a dead center. The best way to explain it is a gun. A revolver versus a automatic, semi-automatic. In a revolver, you can see the bullets, correct? Right now, y'all are all packing .357 Magnums. You have enough information to be somewhat dangerous, but your danger is at a minimum level. You're a Category 1 danger threat. Why? Because your gun is empty, and I can see that it is empty. I look right down the barrel, and you have 0 bullets in that gun. Right? The carrier is very aware of what they're looking at. What do they do for a living? They're risk managers, aren't they? Where do you think the management of risk stops? It does not. It occurs on every single level. Every single one of you have a risk factor that the insurance company has assessed you and what threat you are to them. Right now, you're a level 1. You have information, but the information is jumbled and it's all over the place and it's not organized and it's not triggered them to be scared. The moment that you follow that contract, the moment that you do the duties after a loss and you provide an SPOL to that insurance company that complies with the policy, the statutes, and the facts of the loss, guess what occurs? All of a sudden, your .357 Magnum went from a gun without bullets in it to a gun with hollow points in it. You can see right down the barrel that this guy means business. He has a gun and he has bullets in it, and the fact that he has both and the way that he's holding it tells me that he knows exactly what he's doing. Does that make sense? So right now, you don't have any bullets in the gun. Why? Because you're not getting the full picture. For whatever reason, and well, the main reason is how many schools are there in the United States or the world that teaches what we're talking about right now? Not a one. Not a single one. We're the only one. We've been in existence for 9 years. I'm not saying that as a brag. I'm just saying it simply as a factual thing. We are the only school that I am aware of that teaches anything like what we're talking about. The insurance company hadn't shut us down yet, have they? Means we're not telling lies, huh? If we were telling some lies, they'd be after us like somebody's business, wouldn't they? For them, the best thing to do with us is to leave us alone. Why? Because they don't want to bring attention. The last thing in the world they want to do is put a big old fight out and have this thing go wrong. And we've talked about this yesterday, and attorneys not suing each other. Do y'all find it odd that attorneys don't sue each other? Has it ever occurred to you that attorneys don't sue each other? That you don't see all the time these attorneys who have this badass license that can go after these other attorneys who do bad things? It's because they know something you don't. They don't control the judge, they don't control the jury, and they don't control discovery any further than what either one of those other two will allow. It means that it's a complete unknown, and the other side has a massive amount of power to extract information. Correct? So what do they do with each other? Give each other a wide berth. You stay over there, I'm going to stay over here, and we're going to stay out of each other's way because we don't know what would happen if we got into that litigation. What started out as a good thing may turn out to be a bad thing. The whole insurance claim process should never be like that. You should have a process in-house that puts claims together, that when you put these claims together, you submit the package to the insurance company, and then you get to do what? Be finished. See, the We Pay section says that if you complete that, you do all of those things and check them off. When that's done, and the contract's promise from the insured has been fulfilled, what do you do after that? See, that's where everybody's stuck at right now. That's why everybody has claims that are 6 months old, a year old, 2 years old, 3 years old, is they hit that wall where the insurance company just does what? This is what I'm doing. This is it. Here's a check for what I want to pay you, and it's over with. What do you do at that point?
Thank them for that check and tell them to pay the rest.
Say it again.
Thank them for what they gave you and then make them pay the rest, hold them accountable with the statutes.
Well, that's like telling the dad that he did a good job because he paid child support. Bubba, this is what you're supposed to be doing. That's what happened when you had that kid. You don't get kudos for doing what you're supposed to be doing. Or, today's times it's the same with the mother. I mean, it's not just the father. It used to be just the father, but now it's the mother that's just as much in bed with that. You hold them accountable, right? And you quit playing with them. If you've done everything that you're supposed to do and they didn't do what they were supposed to do, we'll go back to the ticket again from the cop. Now we get to go talk to a judge, and the judge decides whether I was in the wrong or not, correct? The cop doesn't get to adjudicate what's going on out in the field, does he? He simply writes the citation. And then I go to a court of law and I plead my case to an attorney or to a judge. The insurance deal is no different. You caught them speeding. They failed. They broke the covenants of the contract, and the law provides different penalties in different states, but some of our states are very, very good. But guess when those things apply? How many of you have seen a bad faith case actually with your own eyes? Dadgummit. Span around, Rand. Show all of these hands that are showing all of the bad faith cases that they've seen. But you hear it how often? Every day, daily. That's clear bad faith. You got a room full of professionals here, and not a single one of them is raising their hand saying that they've actually seen bad faith verdict. Why? Because they're rare. Why are they rare? Well, we're talking about it right now. If you didn't submit an SPOL, you really don't have the right to sue. What does the suit against us clause state in the policy? Anybody know off the top of their head? No suit shall be brought against us unless all policy provisions have been met. If you were to submit an SPOL and you did not, have you met all policy provisions? You haven't. What do you think the 60-day pre-suit notice is? Is everybody familiar? Raise your hand if you're familiar with the 60-day pre-suit notice. Okay, in many states, and I think almost all of them now,
About three-quarters. Yeah.
about 3/4 of the states, before Shaun, the attorney, can actually file a lawsuit, he has to give a 60-day notice to the insurance company of his intent to do so. Do you know what he does in that 60 days? He does the duties after a loss for the first time for the insured. They have never been done. So when he does the duties after a loss for the insured, it's an attorney doing them. It's not a public adjuster. It's not the insured. It's an actual attorney. So who does the other side have involved? They have their attorney, don't they? See, the crazy thing is what often happens is that when this attorney reads the contract for the first time for anybody on the insured's behalf, he goes directly to the duties after a loss. He performs them as an attorney, not as a public adjuster. He has to get them done because he has to bring the insured into compliance before he can file the lawsuit. So he goes and gets this done for the first time, sits down with a opposing counsel, and opposing counsel looks at it and says, well, dadgum, this is the first time we, as the insurance company, have seen full performance of this contract. Thank you for doing that, Shaun. And they may agree with the estimates and everything that Shaun provided, and they may resolve this claim right here. This is not a crazy thing, correct?
Yeah.
Okay, so what actually happened? The attorneys became very high-priced adjusters. That's all they did was they adjusted the claim for the very first time, and when they did, and then the insurance company attorney says, I have a contract in front of me. That contract requires the insured to do ABC. Mr. Hodge, being the attorney, did ABC. We agree on the damages, and I'm paying this claim at the value that he paid right there. Who's going to pay Mr. Hodge?
Insured.
The insured is, aren't they?
Why can't they bypass the 60 days if all the A, B, and C was done by the PA?
Because it's law.
It's reasonable.
You still gotta wait.
No, it's law. You don't get a choice.
Statutory,
Yeah. Yeah, it's straight up, you don't, and if
I mean,
you
I knew it was
do,
a law, I didn't know there was a
Would
reason.
well, let me say you can,
You
but then the
can?
claim will be thrown out completely and you'll be barred from refiling.
So some states, it can be thrown out. Some states you can lose a lot of your damages. Meaning, if you didn't send the 60-day pre-suit demand, you can't collect attorney's fees as damages. You can't collect bad faith. You can't. So you're limited on what your recovery could be if you try to even file it day 59, right? If you file it one day early, you cut off some of your damages. Sometimes it's very severe, the damages you cut off.
But why would you want to if it's the law?
No, I didn't, I was just asking, I knew it was the law. I was thinking any type of incentivizing.
Is there a way to do
justice
it?
Now, if you've been to camp, and you have, what you're doing is you're making Shaun, you're allowing Shaun to do what he does, and that's to bring the law to it. He doesn't have to become an adjuster. He simply has to verify that what you've done is correct. He has to send his own people. All of that has to occur. But it's not to do the case for the first time. It's to prove or disprove what you have done. Whoever sent the file to him that did their job and said the insurance company has committed bad faith, Mr. Hodge, it's now time for you to bring the law to it. He now has to verify it so that he doesn't get in trouble, and then to build the case, to strengthen the case. But it's not him doing it. It's him verifying, which is a totally different thing. If it was done before he gets it, then all of those fees are on the table. Mr. Insurance Company, the contract was done prior to my involvement. You had every opportunity under the color of law to go out and do what you were supposed to do, and you did not do it. I'm speeding. You're breaking the law. We're both going to get our day in court. Right? At this point, Shaun's attorney's fees become a negotiation tactic. Right? They're not going to take this to court. Why? Because they're going to get their ass kicked. So they're going to offer the insured a number that is close enough to them to make them whole, knowing they're remember they're risk managers, right? They know these numbers down to a T. They know me, they know you, they know everything more than what we think we know about ourselves. So when the number comes, they're going to offer Shaun and tell Shaun, here's X number, right? That number wasn't a random number. That number was a multiplier. It took every known factor that they had, they put it together, and the AI machine spit it out and said, if you put this number out there, Shaun doesn't have a choice. He has to go to the insured, notify the insured of what that settlement offer was, and then the insured does the math. You mean I get that money today? That's number one. And then number two, who pays the attorney? Well, they're not paying the attorney, but here's the settlement number, and you wanted $100,000. The settlement's $175,000. The attorney needed $45,000. The PA needed $17,500. If you look at these numbers, what happened? All of those people got paid. The insured got the original money that they went after, and they get that today. Or we go to there's no money today, and we go to court and let the dice fall where they may. What is the insured going to do? Risk management 101. They're going to take that money. Yeah, it was every bit of it was a risk management strategy on everybody's part, including the insured. You mean I get that money today? Well, kind of, but yeah. We're settled and we're done. So they're going to take that. But the only way that that's ever going to occur is if you're holding a 357 Magnum that has hollow points in it. That they are aware before they get to that courtroom that they have absolutely no choice but to settle this claim or go to trial. When they go to trial, I can guarantee you one thing. There's one of two things going on. They're going to kick the shit out of you, and they know it, and there's no, in their risk management assessment, there is very little chance of you coming out on top of this, or what's more common, they're testing the lines. We don't know what's going to happen. So we're going to throw this one test case out there, and we're going to litigate it, and we're going to do whatever happens so we can figure out where the action line is. Once we figure out where the line is, then we can push everything where? Again, risk management. They're going to the point where they can grab it to and say, okay, this is where the line is. We bring it right here and we back up just a little bit. Our kids do it with us every day. We do it on every damn thing that we do. It's a simple risk management strategy to figure out where that line is. Questions? Go ahead.
So, I have yet to read a policy that actually defines what a proof of loss is.
What?
I have yet to read a policy that defines what a proof of loss is. They discuss it, but there is no standardized form or what is required to be in a proof of loss.
The policy describes it in explicit detail in the duties after a loss. It tells you every single, if you read the duties after a loss, you're looking for a single form, and I see now what's going on. You're looking for a single form that's called the proof of loss. There is no such thing. Yeah, the proof of loss is a package. Only time I could ever really say that a proof of loss would be okay with a singular page is if, say, you had a diamond ring. A singular item that could be described, priced, and all of the information that's required under the duties after a loss. And I mean things like the ownership, all of these things that are technical requirements are there, and they list them out in the duties. But the proof of loss is always going to be a package. Our proof of loss is typically 20 to 120 pages long.
Plus one page.
But the duties after a loss specifically tell you exactly, that's what you're creating. When you do all of those duties, you create a proof of loss package. And then you submit that package. And that's the beautiful thing, because at that point, you know what you are? Done. When that SPOL is submitted, you are done. What you're doing now is facilitating access. Right? You've put your case to the insurance company, and now you need to meet them back out there with whoever they send. I don't give a shit if they send the Seek Now guy, if they send an engineer that's electrical, but you're looking at structural and he doesn't know. We've seen everything that you could possibly imagine. Ask the guy, how did you get out here? I don't know. They called yesterday. Said, could I come out here and do that? And I said, well, I'm electrical. And they said, we don't care. We just need an engineer to go out there.
And so if you look at the statutory language in a lot of states too, when it comes to proof of loss, which triggers the deadlines, it says, once a proof of loss is triggered, you have certain timelines in which to pay. Most states describe the proof of loss as when the insurance company receives all item statements and forms, right, that are necessary to secure final proof of loss, right? So it doesn't talk about a single document. It talks about all item statements, forms, right? That leads you to believe it is just that, right? It is a package. It is a full documentation of all the damages that are there, right? Which items you're alleging are damaged, what the scope of work is, to properly indemnify the insured. So it's more than just a single. You have a summary page that a lot of us are familiar with this, proof of loss that may have RCV, ACV, right? That does not itemize out each individual line item. You have to have the full scope of work. So it's more of a package, not just the summary page.
As the policy requires, it says specifically, we want a detailed, itemized estimate of all of the damages that have occurred, right? And would you want to pay somebody any money whatsoever because you had a contract with them that said you would pay under certain terms and conditions if they were met, that you would pay for these things? Would you want to pay anything that contract didn't say that you paid? You wouldn't, and neither would I. I only want to pay what's legitimate, if I owe it to you, baby, you're going to get it quick, right? If I don't owe it to you, me and you're going to have a fight about it. Yeah, if I don't believe that I owe it to you, I'm going to pull that contract out and tell you point blank I don't. I don't begrudge the insurance company for being a business. None of us should. The part I get pissed off about is the lies, the deceit. I'm a good neighbor. You're in good hands. Let me send my guy out to your house to tell you how much I owe you. When it's an obvious conflict of interest and there's not a single place in the policy that supports the insurance company being the one to come out and tell you how much they owed you. Have any of you ever read that in a single policy? No, you haven't, because it does not exist. The duty to assess the damage falls directly, squarely on the insured shoulders. We've been doing this for almost 20 years, Melanie and I. We've done judges, senators, lowest of the low, highest of the high, smartest of the smart, dumbest of the dumb, richest of the rich, poorest of the poor. Do you know how many of those folks could perform the duties after a loss on their own? Not a single one. And agents and adjusters, let me add those. We've had quite a few agents and quite a few adjusters that we've done their claims as well. Not a single one even knew of the existence of those items. The whole crutch of what it takes to get the insurance claim done correctly, all based upon the lie that makes me mad. My guy's going to come out there and treat you good. He's going to come out there and do you right, and he's going to pay my money to you willingly, happily, and correctly. And the whole world believes it. Go ahead.
When's the 60-day precinct notice get triggered?
All of these claims that are being filed, almost right now, if you look at the litigation that's going on, and it used to make me furious back 10, 12 years ago when they would say, hey, all of this frivolous litigation that's going on by all of these people. And the minute they said frivolous, boy, my blood would boil. Frivolous? These damn insurance companies are doing this horrific stuff and you're saying frivolous. And then not long after that, it occurred to me, wait a second. If 99.9% of the public adjusters and contractors are not submitting SPOLs when they submit these claims, then without fail, factually, there is no question that 99% of this litigation that's going on is what? Due to that one simple, we don't have to go into the mechanics of anything else. We don't have to go any deeper than that singular statement right there. If you're not filing a proof of loss, we can verify both that the policy says it in at least two places, in the duties after a loss and in the we pay section. And for those of you that will say, well, what about the policy that says submit at our request? Again, I will direct you down to the we pay section. And when are they required to pay you? Only after receipt of that proof of loss.
I didn't know anybody didn't submit a proof of loss.
Nobody submits a valid proof of loss with all contractual obligations fulfilled.
But then you come to a denial. You have many people today that are trying to submit them, and the insurance company says, well, we reject it. Well, you say whatever you want. Do you have it? Yeah.
I didn't request it.
Thank you for confirming that you have it.
Thank
The
you
only
for
way that you can
confirmation.
really deny that proof of loss to me and say that it's incorrect is if there's a technical deficiency on there, on that thing somewhere, which happens all the time. We're all humans. We make mistakes. There's clerical mistakes. The date of loss was wrong. The policy number was wrong. But it needs to be a technical issue. Saying that we have that you owe $1,200 and that you have that we owe $112,000, we deny yours based upon that dollar amount. That's improper. There's not a court that I'm aware of that's ruled that that's a proper deal. They've all, in fact, went the other way and said that absolutely is no reason to deny a valid proof of loss. Go ahead.
So when you say like an itemized estimate and like a full report showing the damages, is that what you're saying
I don't
can
think
be
so. Go into
considered
that.
proof of loss?
Yeah, well, it would be part of it. Remember, we're talking about a package. And that duties after a loss lists that specifically. It has its own line item for it that says, give us a detailed, itemized estimate of how much it's going to cost to put that property back together. Okay? Lump sum. Not going to work. I wouldn't pay off a lump sum. Why? Because I want to know that I'm only paying for what I want, and I'm not paying for anything that I don't want. And more specifically, if you tell me you're going to do a job for $30,000, say I'm going to come to your house, I'm going to do the electrical for $30,000. What are you including in $30,000? Am I going to get the rough end done, and then you come back to me and go, hey, it's going to be another $45,000 to finish it out? The shit do you mean? I thought you were going to. No, that was just no. And when we detail and itemize everything out, what happens? We're all certain that we're getting exactly what we're supposed to be getting. Nobody should be upset about it being detailed. We should always put ourselves in a light and ask ourselves if we would do the same thing if we were the one paying. Right? Whoever's paying shouldn't make a difference. Right is right and wrong is wrong, correct? So it shouldn't make a shit who's writing the signature on the check. What should matter is that we followed all the rules and we've done exactly what we were supposed to have done. If we've done that, where's the hiccup at? It's on them. It's on them. The we pay section allows you to close the claim out. As a public adjuster, as a contractor, whatever it is that you're doing, I don't suggest that you go out and try to do PAing, but I know what's going on. And if you're out there, you need to get to a sense where you realize there's a point that you get done with a claim. And it should be quick. It should be 60, 90 days. You should be through with the claim. Why? Because you've done the duties after a loss, you've done the we pay section, and you are now complete. Why would you wait any longer? Everybody familiar with what the hedge is? No? The hedge is the money that the insurance company, well, it's your premiums, put it bluntly. They take your premiums and they put them in a different company in a different account, and they're allowed by law to do so. When that money hits that hedge fund, it goes dark. Don't nobody have any idea where that damn money's at, what they're doing with it. We know what they're doing with it, but we don't know how much. In other words, Warren Buffett, you may write this down. Check out Warren Buffett later and research the float. He made most of his money, and he admits it in public in front of everybody, on the float. The money that we know we owe but still sits where? In my account. I'll give you a simple example of this. We're all come from about the same strain. I don't think anybody's filthy rich in here. You have a mortgage payment that comes out. You write the check on the 17th of the month. You send that check in, but that check never clears till the 10th of the next month. You're on a budget. You don't have extra money. You do this every month. You send that check and everything's good. You send that check this month on the 17th, and on the 19th, that damn air conditioner goes out. Son of a bitch. Right? And it's going to cost about $1,000, and you don't have $1,000. Or do you? Did that check cash from your rent yet, from your mortgage? Has the mortgage check cleared? It has not. How many days do you have from now until the mortgage check clears? 15 or so, correct? So in your books, you have written this off, and your balance is true and correct in your books. But what does your bank account reflect? That money's still sitting there. So if you can take the $1,000 out, now that's highly illegal. You're not supposed to be doing it, because once you tender the cash, it's supposed to be there. But you take that $1,000 and you go pay for the air conditioner, and then you put it back before the 15 days. That's in essence the float. They are taking that money that is sitting there, and it's supposed to be gone. It's supposed to be doing something else. They take that money and hedge on it. Stocks, bonds, everything that's going on, and don't forget that you report to them before you sell anything. So they have a kind of like an insider trading deal. They get information about whatever's going to happen before it happens by their contracts. Hey, if you're going to increase production in corn, Mr. Hodge, you need to let me know when. Before you do it, right? Yeah. So I'm giving you a heads up, and if you're going to stop the shipping, what do you need to do? Tell me that you're going to stop it so I can decrease your premium. They're getting a heads up before and after on that stock. And they use that money to hedge it. The only way you can stop it is to perform under the contract. When you stop it, exactly. The faster that you get that claim to where it's either paid and closed, or you paid a partial and you're going to litigation, the better off everybody in the world is, except for them. And I don't want to hurt them. But if you were supposed to pay the money in X amount of days, then what do I expect? I expect payment. And if you don't do payment, then I expect what? Consequences. Yeah, I want you to have consequences just like we have. Everybody in this room, if you walk out of here today and you get a speeding ticket, what do you got? You got consequences, right? And they're not singular. Not like you just go down and pay the ticket and it's over with. No, you're going to have to do defensive driving. You're going to pay an increased premium. There's going to be a whole litany of things that go on with this because of the decision that we made. The same should hold true for everybody. The law should be the same for all of us, and if you break it, you should get in trouble.
Is that when you're submitting the pre-suit notice? When you're starting to have trouble?
No, we don't do that. That's legal.
No, the legal would do pre-suit
That's what I'm
notice.
saying. Now, when you have your lawyer submit that pre-suit notice, when you're having trouble getting payment?
But shouldn't,
So the pre-suit notice is, if you look at all the different areas of law, let's just talk about just a regular contract, not an insurance contract, just a regular contract, right? You're in business with each other, you have a joint venture, you have a contract, operating agreement. One of you breaks that agreement, you can go file suit tomorrow against them. You go out and you drive down the road and you get in an accident, somebody hits you, you can file suit before 5 o'clock today if you want to. This is one of the only areas of law where you have to say, hey, let me get your attention, 60 days from now I'm going to file a lawsuit against you, right? And so why do they do that? It's because under the insurance policy, the insurance companies wrote that in there. Before you file suit against us, you have to check all these boxes. And the reason the state requires you to give that 60-day pre-suit notice is most of those boxes have rarely have ever been checked if somebody goes and files suit on day one on a policy. That's why it's kind of a cooling off period. The attorney has to make sure it's all been complied with, submit it to them, give them the heads up before they file suit. Otherwise, like Cal said, it's a frivolous suit.
they created it. Understand that nothing that's going on right now is not something that they didn't create. They created the problem by convincing everybody they had no responsibilities. You convince the world and tell them that I'm a good neighbor and that you're in good hands and that my guy's going to come out and perform your contractual duties under the contract. Before long, people aren't doing it. Next thing you know, the entire population is not doing what they're supposed to be doing, which means that all of this litigation that comes in, you can expect that they wouldn't have checked the box off. They didn't even know there was boxes in. You mean I got boxes to check? Yes, you have a lot of boxes. But if you look at the contract on its face, you look at the duties after a loss, and then you listen to any commercial that they have come out. You walk out and you go to any non-insurance person. You walk out here right now and go to the person that's running the concession stand out there. They have a home, and you ask them, if you file a claim, what happens? Well, I call my insurance company. Okay, and then what? Well, I wait on their guy. You wait on their guy to do what? Come and tell me how much I'm owed. Does the contract say that? Does the contract support what they're saying in any way, shape, or form? But what is the accepted way universally? Just step to the next insured and ask them what would happen, and they will tell you the same answer. I call my insurance company, and I wait on their guy. That was never supposed to occur. So understanding that they cultivated the environment that we're in. Then when the environment that we're in got them to a point where they could say, hey, look, legislative body, these people are filing all of these frivolous lawsuits. How do we stop that? Well, it's very simple. We install a 60-day pre-suit demand notice to where they have to check all the boxes, and then we'll make sure that the only things that come to actual litigation are things that have checked all the boxes. Do you think the plaintiff side was controlling all of that, or do you think the insurance company was controlling all that? Do you know how much control that represents? That's getting whole state bodies to do your bidding. Whole members of Congress, state representatives, all of these people to get in bed. And it wasn't as hard as you may think. In Texas at one time, our whole insurance, what do they call that, the Senate committee on the insurance? They absolved it now, I think. Craig was on it.
Oh, the Insurance Oversight Committee?
Yeah, the Insurance Oversight Committee. Guess who all of those people were except for a handful? They literally
Insiders.
owned agencies and had stocks and things involved in the insurance. In other words, for the lobbyist to come to the insurance guy, it's really simple. Hey, last year you made $225,000, right? Yeah. We have this legislation here that if it passes this year, you'll make $500. If it doesn't pass, your $225 that you made last year is going to go down to about $175. I didn't have to bribe anybody, did I? I just had to look for the right people to support to get it in the right place that would understand the language that I'm speaking, and that's not a hard thing when you're talking to the risk managers. Very simple. From Larry Taylor. He was the head of the whole deal for a long time. That guy owned a big old huge, he's the one that did TWIA. The horrible things that we see with TWIA and what they do were a brainchild of his. And I imagine Badger and a couple other people had.
If you look at State Farm agents and other agents, the insurance companies, want their agents to run for statewide office.
Oh, yeah.
They say, oh, we'll give you extra time off, right? Well, oh, yeah, we'll pay your full salary while you're up there in Austin. We can do that. So they urge and encourage and promote, their agents to seek office. So, but I mean, the 60-day period, if you look at it, it really serves two different purposes. It's a bonus float, right? It's like an extra 60 days, and then we file suit, and they got to serve us, so it's really another 30 days. So you get like 90 days extra with this just timeout period. Plus, what else do you get? They have like 90 days advance notice before you attack. When do you call up your enemy and say, hey, 90 days from now, we're getting it on?
Specifically 90 days.
90 days from now, set the clock. So that gives them a lot of time to internally circle the bandwagon and say, hey guys, are we all on the same page here? Right? This house had no damage, and so they can start redacting things out of the claim file. They can sanitize the claim file, they can clean it up, right? Now, they're only supposed to do that after that point in time happens, when they get that, but that's something I review when I get the claim file in. When did they start redacting it? When did I send my pre-suit demand, right? Because sometimes they try to jump the gun early and start redacting things.
We're just going.
Shaun, I kind of know the answer, but still to elaborate. If that many people don't understand policy, don't understand duties after a loss, and an expert is required, such as the public adjuster, as one would be needed for engineer mitigation roofing contract, why can we not get them to where PA fees are paid as it's required to fulfill their portion of the policy? Every other expert gets paid.
I've
So
gotten
part of
it
it's
in
the way
about a
you're-
handful.
yeah.
I have gotten it and
I remember we discussed
Yeah.
that before.
We've gotten it paid on a number of files, and
Yeah.
you know, it wasn't like it slipped through, and they're like, "Oh, we didn't realize we're paying PA fees."
No.
That was the topic of discussion. They realized they were doing it. And so in Texas, Florida, other states, it's happened. Now,
What we're working
I'll
on.
say, legislatively in Texas, it passed the insurance committee last time. It made it through the whole House of Representatives, and it died in the Senate. The Senate did not vote on it. There was just about 100 bills that came over, and time was running out, and they were like, we have 100 bills here, we got to pass these 15, and they voted on them. The other 85 never even got a hearing, and they just died in the Senate. So, but there was a bill in Texas that made it out of the House of Representatives, that just died in the Senate, that would statutorily institute public adjuster fees, right? And so there's going to be another big push next legislative session to try to get that through. So it's like tipping over something heavy, right? You got to rock it a few times before
Actually,
you get
it's
the momentum.
upriding something that went wrong.
I would
Remember
like
from
more
camp, they paid the
accountability
PA fee in the beginning.
Yeah.
So I'd like more accountability because I don't want all of Florida.
But,
PAs
and
coming to
it's,
Texas
we
to
shouldn't
write
attack it
out.
as a recourse then, because then you go into saying that it's extra contractual obligations, which makes you the judge, jury, and executioner. We don't want any part of that. What we want is an understanding from the beginning that the things that you've asked the insured to do are not possible for them to do because it's not what they do.
Correct.
In the beginning of insurance, before all of this went south, prior to 1921, they paid the PIA fee out of the investigative part of the funds. In other words, it didn't come from the insured's funds. It came from the part that the insurance company had set aside for their part to investigate that claim. That's what we should revert to, and that's what we should be pushing for. Not because it's a penalty to them. No, but you asked the insured to do some very specific things. We're not talking about a 165-line policy that a ninth grader could read and understand. We're talking about a 40-page policy that it takes a postgraduate degree to read and understand, or somebody like us that's read it so many times that we finally we got it. Right? I put State Farm policy, standard homeowners policy through Grok AI and asked it, at what grade reading level is this? And it come back postgraduate. Each sentence has 5 different components in it that you have to understand inside of a singular sentence. That is postgraduate level reading and understanding. So the push should be absolutely for it to revert, not to be the cart to be pushed over, but for us to pick it back up and put it where it was supposed to be. An independent third party, the public adjuster, has more penalties in process than anybody involved in this thing if they do something wrong. We're one of the most heavily regulated. If you commit fraud, it's very easy to find. Right? You submit it and put it in paperwork and give it to the insurance company. If you committed fraud, we can come get you very easily. Right? So you're capped at 10%. Your regulation is over the top. You're the one that should be out there adjusting that claim. And if you do it wrong, you should get in trouble. Right? Now, I don't mean wrong by going out and you made errors and there was human mistakes. I mean, if you're going out there committing fraud, you should go your ass to jail. And they should stick your head on a spigot out in front of everybody else and tell you don't do this. It's the only way that things stop. Right? How do we stop people from eating deductibles? You send about 25, 30 son of a bitches to jail real public, and guess what will happen to that eating deductibles? That shit will go by the wayside. Why? Because the fear of getting caught overcomes the fear of what the deal is going to be. And we can write that course. Right? But they're not willing to do that, are they? Do you think they don't know who's eating the deductibles? They know precisely who is eating the deductibles, and they're allowing them to. But see, this 60-day deal that he's talking about, there's another benefit in there inside of that. If you're the PA on the file and you've sent 5 or 6 to litigation, we don't like you now. In this 60 days, we're going to investigate you. We're going to overturn every stone. We're going to go through every part of your life. We may even get a hold of the Department of Insurance, which is very common, and they may initiate an investigation on you on our behalf. So now we're both looking at you. Yeah, there's a whole lot of things that go on in that 60 days.
It was planned.
And that's when you're the people that are eating deductibles, they'll tell you, well, I've been doing it all my life, okay? And it takes how many times for you to get in trouble? That's it. And then the problem with you doing it all your life is when you did it one time, all I got to do is go back and start looking at your books. I'll prove every damn time where you did it, and all I need is one opening, right? I need you to let me in.
I just have a quick question about, because we're talking about the fees. So are contractors legally allowed to absorb all these fees?
No.
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 So like.
Insurance is dollar for dollar.
Fees.
Yeah.
So it's the insurance responsibility to pay all these fees?
It is.
Okay.
But think about it like overhead and profit, and it should be at a minimum in 15 and 15. What you've done is you've put a blueprint together, and you've taken all of that stuff that's going to happen has been done by you, right? That's part of that overhead and profit, and that's where that money should come from, in my mind. You have absolutely performed all of these things that are necessary. You now have this blueprint that is absolutely a blueprint. This is how you get out of this thing. And it doesn't matter who it's for. Who does the blueprint fit? It fits the insurance company, it fits the contractor, and it fits the insured. It fits all the way around. Would you agree with that?
Absolutely.
Yesterday we heard it was talked about that states are starting to adopt DRP languages, and how is that going to impact the PA world and just contractors in general?
Well, it's been in
What
effect
did he
in
say? What?
Florida the whole time, right?
What language?
DRP.
The DRP, so if you don't use a direct repair,
Yeah.
if you're not on the program.
Oh, they're
Managed
great.
repair
They're
program.
great. I love
RPE,
them.
and, yeah.
It shouldn't affect you at all. It becomes a very simple thing, right? You submit the SPOL, and Mr. Insurance Carrier, whoever that you say is going to do the job, if they perform these things that you promised under the policies, you can let whoever the hell you want to. If they don't, we got a problem, right? You're not arguing about the scope of work. Who repairs it? None of us have the right to say that. That if you've got a managed repair, then that's what it is. But do the repairs comply with what your SPOL submitted was? Do you understand what I'm saying?
It's still the
No?
same argument.
Nothing changes.
Yeah, it's still the same argument.
And they don't, we've had them try to do the managed repair with us one time, really. It doesn't work out for them. Why? If you say that you got a guy that's going to do it cheaper, we just agreed it was a dollar for dollar process, right? How can that guy do it cheaper? The question's glaringly simple. He can't. He's going to have to do what? Remove legitimate items that were covered in order to get it there, and that's where he runs into the problem at. You don't do OSHA? I'll have a guy there the first day. It doesn't take but once or twice for them to decide, everybody involved, the contractor and the carrier. I don't want no more of that. Why? Because they're out there looking. Right? We didn't have OSHA, and that son of a bitch called OSHA on us, and they come out and they find us $180,000 because it was $20,000 a guy. We had 20 guys out there, and we all got fined. Is OSHA a suggestion, or is it a law? It's absolute law. And if they're out there doing it without it, that's how they're cutting costs. Which all sounds well and good till somebody actually falls off the roof and gets hurt. Right? Then it's a big problem, isn't it? Or OSHA shows up, and in Florida, they're everywhere. Yeah, you don't really have to call them. They're all over the damn place. You don't have workman's comp. All of those things that are required in there. They can't go out there and do the job. If it's dollar for dollar, right? You understand what I'm saying when I mean that, right? We wrote a scope item. There was a dollar accounted for that. There was a labor accounted for that. And there was an overhead and profit accounted for that. If you're going to do the job for any cheaper, you've got to show me how you're doing it. How did you bring, you can't cut costs. You can't cut legitimate line items off and go do it and be okay. In other words, the managed repair has to follow the SPOL that who submitted? You. Did you lie in the SPOL? You didn't, did you? I hope not, because that's fraud. So you put the SPOL out, and so what should be the standard for what they're doing? What you said or what the insurance company said? Huh?
What I said.
Exactly. As long as you comply with what the policy said, the facts of the laws and the statutes, you're the king here. Your license grants you that authority. And if they're not going to do it, they have to prove to you what allows them to do it. Give me the policy and show me where it says in there that you don't have to do this. You know how many times they've done that for us? Never. They just issue a check out. We're just going to do, yeah, that puts you in trouble. You're in automatic trouble right now. You denied all of these damages that we put on there. The moment that we put it in, it becomes a reasonable demand. Your SPOL together becomes a reasonable demand, and it says so on all of our paperwork. In order for this man to get attorney's fees, almost every state has a trigger on the attorney's fees. The insured when they recover, it has to be close to what the reasonable demand originally made before this guy ever got involved was. If you don't put a reasonable demand, what does that do to the attorney's fees? Takes them off the table. If it takes them off the table, it means that we can't make the insured whole under any circumstances if the attorney is involved. The best that we can hope for is that we got the whole number in and that he takes his fees out of the whole number. And then we all get mad at him and call him an asshole. Well, the attorney took, 35% of that money. Did the attorney get it paid when nobody else could? He did. Did you do your job before the attorney got there and make sure that the attorney, if he got involved, could get his fees? No, you didn't. So who's the asshole here now? You are, for putting it in the place that it went to. He took it in and probably took it for less than 35% because he don't like making the insured not whole either, but he's got to make a living, doesn't he?
Does everybody understand what Cal was just saying there with the numbers? So when you send in the pre-suit demand, right, there's a lot of different factors in play. We talked about the bonus float. They have time to do things on their end to get ready and anticipate litigation. But one of the additional caveats to that is when I send the pre-suit demand, I have to accurately predict what that final outcome would be from the judge and jury 12 months down the road, 18 months down the road. Meaning I have to give a demand, and ultimately if we go to trial in the case, my demand, my pre-suit demand is going to be compared against what the jury verdict came back at. And if I demanded an amount and I can't get 80% of what I demanded, if I demanded $100,000, but the jury verdict came back $75,000, I was off by 25%, you start losing attorney's fees as a penalty. So you have to accurately, you can't, the insurance company said, well, we wanted to get an accurate demand because we don't want the attorney saying $1 million on every claim. Give us a realistic demand and we'll decide if we want to pay it or not. That's how they snuck it in, right? What's the real purpose of it? If you can't accurately throw that dart and hit the target, right, you're going to lose the right for attorney's fees. That's why you can't write fluff in your estimate. You can't pad your estimate. You have to write things dollar for dollar that you can prove.
And you can add attorney's fees if you do it off demand.
Us?
No.
Yeah, I can add attorney's fees on top of it. I have to say, here's the actual damages, and here's the attorney's fees we're going to be seeking. Right.
Plus, but if you wait, not likely.
Yeah.
That's what
I mean, there's certain things that trigger the attorney's fees, but you lose the right to even collect and even ask the jury to award attorney's fees if you don't send the pre-suit demand, and then ultimately if that jury number comes back and it's less than 80% of what you demanded, the judge, after the jury verdict comes back, is going to say, oh, you only got 25 cents on the dollar for what you demanded, therefore you lost the right to collect attorney's fees.
So when you're saying the estimate, you're saying the PA's estimate that we write as a PA. So then that's the part that I have a disconnect with is the PA to the attorney, right?
Right.
So I guess why I'm afraid to ever get an attorney involved in a PA claim is how do I get my piece for what I've done? Because when I go to an attorney, the last time I got burned.
Well, you have to get all of your documents correct, which is what the part of process and part of class that I teach, which is process.
Okay.
So if you sign it correctly, and then I'm going to go into Michael, right? I'm going to go into you. But when you sign it correctly and you fulfill what the contract says, because that's what the policy is, it's a contract. So once you fulfill actually what it says and you go all the way down through it and you do fulfill all of that, then your SPOL goes to that part. But in order to get it to an attorney, to get litigation, any of that, you have to do your job accurately, right, as best as you can. And then what's left is what the attorney gets. Not any part of what you actually, if you wrote $130,000 and you got 80, that remainder is going to go to the attorney. So when you do that, and actually when you implement the documents that we provide in class that have been reviewed by a lot of attorneys, it protects you. So when you do send it to an attorney, you will get your fee out of it.
You still get your fee.
What state are you in though?
Texas.
Oh, okay, yeah, so you can transfer your file, and when your file is transferred, that document is included. So that attorney, he won't be able to release your portion. It has to sit in escrow until the insured says, yes, go ahead and pay them. So he can't release it to them, anybody,
Let me go just a
but it's
little bit deeper.
protection.
If you performed your job, did you do the duties after a loss?
Yes,
Okay, you did them fully.
yes.
Okay. When you completed the duties after a loss, do you know what you did? You completed your portion of the claim.
Right.
I've seen so many PAs get tripped up in the deposition question. Well, you did, you went out, you wrote an estimate, you did this, you met with them out there, but they didn't pay. Why do you think that you're owed a fee? What did you specifically do that nets your fee? The answer is very simple. I performed the duties after a loss for an insured completely. Would you agree that I did those things? Can we go back to that contract, pull the duties after a loss? Check. Every one of those, yes? Can we do that? Okay, then I've earned my fee. I didn't have any control of whether the insurance company paid or not. Is the product that I provided to you true and correct? Yes? Okay. Then I completed everything that I could. Payment was not on me. It was for me to do what? Fulfill those obligations under the policy. I'm done. It's over with. We go down to the we pay section. We check off those. All of those are just a reiteration of what went on in the duties after a loss. You got to do these things first. So there's nothing new down here. It's just a checklist. These are what we require before we actually have to issue you a check. If you've done that, and this is where you go immediately to legal. If they failed at this level, it's not a failure on your part. It's a failure on their part, and it is time for them to face consequences. Does a couple of things. You're done. I'm finished with this damn claim. It's going to litigation, and what am I going to get to do now? Go to the next claim. And not have all of this baggage hanging all over the top of me about what I've got to go do and mess with these guys that have no intention of paying the claim. I'm finished. It's going to litigation, and I'm going to the next claim, and I'm going to keep moving forward. It's the only way that we as PAs can run a business. If you look on your books and you have 500 claims and only 60 of them are from this year, that's a problem, right? You have all of these claims that are not being closed. We talk about that float money that we were talking about earlier. You think about that float money. I know a lot of people, a lot of PAs that had a lot of claims on their books. Every one of them is float. If I owed you $1 million and you've got it jacking around in the deal for 2 years and you never even got it to an attorney, I got to play with that money the entire time. By play, I mean invest, make more off of what I owed you, but I didn't want to pay you. And if you don't have an answer for them, they're going to keep doing it to you. Yeah, the answer is not to bury your head in the sand. The answer is to get to a point where you say, okay, I'm done with this claim, and if you son of a bitches don't do what you're supposed to do, then I'm suing your ass. And I'm having somebody else do it. It's not what I do. That's what he does. I'm going to continue doing PA work. That's what I make money at. That's what we earn at. That's what I'm going to do. I'm going to do my job, and then I'm going to move on. And I'm not going to let them hold me down. They have got the whole industry in a paralysis where people have got all of this money all over the place, right? They don't let them go. And they're controlling that whole flow. The contract and the statute takes that away from them. You do what you're supposed to do. They have a statutory timeline that they're supposed to get it done. If the statute, you live in a state that doesn't have a statute that defines it, then you go back to that we pay section, because what does it say?
We must.
Once we have all these deals, and we got a specific amount of days that we get to pay you, maybe 30, maybe 60, maybe 90, but that absolutely tells you in the we pay section at the maximum, this is what we have. If this is greater than what the law allows, then we're going to revert back to the state law. Like Texas, you have a policy that says we'll owe you in 30 days. Texas says bullshit. You got 5 business days from the day that you know to owe to get that check in the U.S. mail. So in other words, that state law trumps the policy. That's the only time that you're going to see that. The policy is going to be king at all times unless it breaks the law. And then if it breaks the law, it reverts to the minimum of what the state law requires that, which in Texas is that 5 business days.
If it goes to litigation, I'm just curious, can you also adjust the fee?
As a PA?
Bless you.
Yeah, I mean, yes, that's an element of damages that I can. And like I said, I've had it paid here in Texas, Florida, other states and jurisdictions. There's a body of case law that's just starting to be developed on that, right? And so There's only been a couple court opinions out there on it, and there's no states that have any statutory rules, right? So this is all judge-made rules, right? And so we're pursuing it as consequential damages, additional damages, but yeah, we've been successful in getting those paid.
And I don't like that. That's one of the few places that we're at odds. He's having to do what the law requires him to do. I don't like it because I don't think it should be consequential damages. This is what you required the insured to do. The policy requires you to do it. And he understands my argument completely, but he has to work within the confines of what he has. If the policy says to you, and it does, go clean the damages up, right? We call it mitigation, correct? Protect the property from any further damages. Okay, if you can't do that, what does the policy do? Whether you can or not, but typically will say that you can't. You have to hire an outside person to come out and do that. What does the policy do? Why does it pay for it? Because it was required under that policy. In order for you to get coverage, you were required to do it. It didn't say we'll pay the mitt guy, we'll pay the roofing guy, we'll pay the tree guy. It didn't say that we would pay any of those individually, did it? It said we would pay anybody that you took that was reasonably necessary to get this thing to a safe condition. Okay, the duties after a loss are the same thing. The policy requires you to do the duties in order to get coverage. If you can't do them and you have to hire somebody to do them, then the policy should pay for it like it used to. If you can't perform these duties, but yet they're a requirement for you to obtain the coverage, the policy requires you to do that, no different than it required you to mitigate. The only thing that changes is the fucking moment that you put PIA in front of anything, the insurance company is an automatic no. No, we are not.
That's why they created the represented claims department.
The what?
The represented claims department.
Oh,
Anybody that
yeah.
files claims, they move all of our claims to a representative claims, which means PIAs are on the file. But you have to fulfill the duties after a loss, and that's where we're gonna go. Contractually, it is outlined in every single policy under Section C conditions. And when you're looking at the duties after a loss, it says you must, UPC and Wellington standard every single time, you must provide on their supplied document. You're gonna have to ask them for it because they don't know what the hell it is. But it says you must, and what fulfills of duties after a loss at SPOL is it has to have the named insured, the interested parties, the date of loss, the cause of loss, the property, as well as a itemized valuation. The only thing you're not doing when you're signing that contract is that itemized valuation immediately. So as long as you provide all of that, and it is sworn, you put the penalty of perjury in there. I think it's 81605, whatever the penalty of perjury is for statute in this state or whatever state you're in, and it is signed, dated, everything is fulfilled on your contract, and then you put that itemized valuation. That is what constitutes an SPOL. So
The
on
whole that
UPC
comes
in
together.
Wellington, you're going to have to get their document, and all you do is fill all your numbers in exactly as it requests, and it says no other interested parties in this. That's where you put your company name, because if you do not put your company name there, you're not going to get on that check. But once you fulfill all of that, and if it says it must be a sworn proof of loss, penalty of perjury makes it sworn. Sworn is not always notarized. Notarized is always sworn, correct?
Correct.
I said that right? I always get it backwards. So as long as it is sworn, the only thing you're missing is your estimate of damages. But that's why it is a package, because it has to be all of it fulfilled. If it says sworn and notarized, that's where you run into UPC in Wellington, because that is a part of their standard policy. It must be on their document. So you just fill it out, attach it, put it as one PDF, submit it. We have received your estimate. Great. Thank you for confirmation. We don't see an SPOL. What don't you see that is fulfilled? Because every part under Section C that says you must provide to us, you must file the claim, you must mitigate, you must contact the police, you must contact the credit card authorities, whatever. And then it goes to about C part, and then it says you must provide to us within a certain amount of time, sometimes, a sworn proof of loss. And then you have about 8 or 9 check marks, which all of that is encompassed in normally your contract, if you have the penalty of perjury statement on there. And then the only thing you're missing is that itemized valuation. So once you get that itemized valuation, there's nothing missing. You have fulfilled all of it. So they can argue all they want. Same thing with the word LOR. Me and you were talking yesterday, and you're like, oh, I submit my LOR. You might want to be cautious on that. In a deposition, they will hold you and they will sit there for 30 minutes to an hour on that language because in layman terms, you're representing yourself as an attorney. Although you're not, they're just trying to get you pissed. We never use language that we have been deposed on for time and time and time and time again because that just gives them ammunition. So language is key. Always look at the policy. Policy is Bible. Whatever that policy says under Section C conditions, SPOL, you must, that is what you have to fulfill. I could care less if they call it an estimate. We're moving forward. Keep moving forward every single time. So every single time, every policy does actually say named insured, interested party, date of loss, cause of loss, time of loss, as well as an itemized valuation. As long as you fulfill all of that and the penalty of perjury statement is on there, it is a sworn proof of loss every single time.
What do you use in lieu of LOR? What do you use in lieu of LOR?
Notice to insurance company. It says in the law and in all of our requirements under every state, except for Florida, you must notify the insurance company. So that's why the documents that I sent you are named NTIC.
The only reason it's different in Florida is because you have to give the whole contract.
You have to give the whole entire contract
In essence,
to the
what we've done
carriers.
is we've taken what's sitting inside of most duties after a loss sections, and we've incorporated every single thing that we possibly could inside of the contract itself.
Because you know
That way,
policy.
when you do it, as long as you fill out each section of your contract, which you should be doing no matter what, is if that contract is completely 100% filled out, you have done about 75% of the proof of loss right there. Now you're going to add to it, and you can add to it at any time. You can change that proof of loss. You can amend that proof of loss at any given time as new information becomes available, and I would expect you to, and they should as well. Something new came along, hell, it may go up, and it may even go down. You know, we've had times where we found something that was wrong with what we did. We went back and revised it down. So it's not always going to be up, and it's not always going to be down. It's the ability. Hello,
You
young
need us?
lady.
Yeah, I just need your beautiful faces to keep doing what you're doing.
Just
Love
stepping
you.
in.
Here's an observer.
But this becomes imperative that you create processes that this happens no matter what you do, right? No matter how many people you bring into your office, no matter how much you expand, you must have a process in place that everybody does it precisely the same way. And what way is that? In conjunction with the policy,
Business
with the
record.
statutes. Yes, if you have those things, you become defensible. If you become defensible, the insurance company doesn't have anything to get on you, correct? When you bring a claim in, it doesn't become about you. It should become about the merits of what that claim is. So what we want to see everybody do is remove all of those things out of everything but what the process is that gets you from signing a claim to closing a claim out. Do you have the power to make the insurance company cut you a check? You don't, and you never will. Quit running your process like you do. Run your process like a process. You open a claim, you finish a claim. If the insurance company failed to do what they promised under that policy, then they've done what?
Breach contract.
They've broken the damn law, hadn't they? They need to face consequences. The only way they're going to face consequences is if you do your job and you close the claim out and you get it to an attorney that knows what they're doing. Not all PAs are created equally, and not all attorneys are created equally. You have some that are good, you have some that like to settle, and you have some that'll take it to the limit. And when I say take it to the limit, I want to see change. I want to see a revert back to what the insurance policy was supposed to have meant. If you take my favorite part of the policy is the additional coverages, fire truck coverage. The policy reaches out as an additional coverage and pays the fire truck fee. If you say, and if you live in the city and you have trash and sewer, you will never see this. But if you live out in rural America where you don't have sewer, you have well water, and you burn your trash, you're going to see this charge if you call the fire truck. They're going to charge you at least $500 to have that fire truck come out. The original 165-line policy paid, and the policy still today pays for it, which is what I think is so beautiful about it. It shows the true intent. The policy pays for the fire truck fee. No deductible, whether there was damage or not. Okay, so you take a single mother living out in rural America. Fire starts. Somehow they get out there and they put the fire out. She doesn't have $500. There's no claim because they put the fire out, so she doesn't have any money to work with inside of the claim itself. They put the fire out, and she goes on about her business and thinks, thank God my house didn't burn down. 2 weeks later, she gets a $500 bill from the damn fire department. She don't have $500. She submits that to the insurance company, no deductible, no damage necessary, and they pay that $500. If that ain't some good shit right there, I don't know what is. That was the true intent of what the policy was supposed to be. This person bought this policy, and this policy promises that if anything happens to them that we've got covered under this contract, man, we're going to make it right, and they're going to be okay. And they did that for a lot of years. But they did it to lull us to this point. They didn't do it to be good guys, I don't think. They did it to lull us in. The drug dealer doesn't come out and sell you drugs right off the bat. No, they come and give them to you, right? They give them to you until you become dependent on it. The first time that you come and ask them for them, now you got to pay for the son of a bitch, and you don't have a choice. This was the same way. They couldn't convince us all that we should allow the insurance company to come out and do what they're supposed to do without first convincing us that they were going to do a decent job at it. And they did that. Anybody that's older that was around when I was first around back 25 years ago doing construction, we met with an adjuster out on site, and most of the time we agreed. They paid a check, they went our way, we did the damn job, and it was over with. That was the lull to get us to a point where we thought it's okay to let the insurance company come out and tell us how much they owe us. Go ahead.
What you were saying earlier, so when you do the paid reform boot camp, you provide some of the additional documents that you're talking about as well.
I
We provide
every
all this.
document that I produced.
And you guys do them local in Galveston where you guys are, or where do you guys?
Yes, in Santa Fe.
We were in Galveston for a lot of years. We finally moved up to Santa
We
Fe,
sold our
but we
building
all
and
still
we
still in
moved.
Galveston. Sean's still in Galveston.
Right?
Yeah, it's 15-minute difference. But yes, I provide every single document.
Who would I reach out to?
Any one of us.
Yeah.
Yeah.
That one.
April 6th through the 10th is the next full bull.
Yeah, but
Well,
in
we have
order-
two separate camps. We have an exactament field advanced training that we, you'd be surprised. It's kind of like the other deal. Everybody says, we know, and then they get there and like, holy shit. Yeah, and then the regular one is April
6th through 10th.
6th through the 10th.
But when you come, he teaches from 8 to 10, I come in at 10 to 12:30, and then he picks up 1:30 to whenever y'all leave, which normally I'm starving because he doesn't get home until 8.
The camp's typically about 45 or 50 hours.
Yeah.
We 40 hours is not,
But I provide every single document
Nobody
from
wants to leave.
signing the claim. I talk about also forming your companies because that's kind of my passion, my forte, and where I started when I was 15. And then I also teach you because in order to get him to be able to do his job, us as public insurance adjusters must do our job, and we must understand what that job is. So if you don't file the necessary documents, you don't have the requirements in your documents as well as going ahead and running clean files, which that is also what I teach 5 days a week. When you build that, you have to have process. That process can't change. Once you get your process, you must stick to it because that's the only way business record is involved. The only way that he can actually represent PA claims in the insured is to prove this company does business record, one. And they did their job. They filed the necessary complaints. They did everything required under that contract. Because the very first thing that they do, the carrier, is they breach contract. You have to use language. Language is key. You have to know policy. Once you know that policy, like UPC in Wellington, if you get a lead call and they say, I'm with UPC, instead of doing the normal rigmarole, going through all of the discussions, we have to also then go tell them, well, we have to do another step because we have to get this document signed, sworn, and notarized before we can submit your SPOL to fulfill your contractual obligations. And everybody was always, what's the silver bullet to public adjusting? There's two. You have to follow policy, you have to know policy, and you have to do the duties after a loss. That is your job.
Process.
Once you fulfill that and
Process
you
is
do
the
it
silver bullet.
clean, and you do it as required, step A through Z, you don't cut corners, you don't do anything different on this mobile home than you did on the $50 million structure, you've proven business record. He can take that, he can run with that, and sometimes he can go above and beyond because you did your job.
I think I've fallen down the rabbit hole that most of us do, right? I got my PA license 4 years ago. I have it under my firm. I've been doing appraisals. I joined Tapia. And then it's like, you go get, I mean, right, what does the license teach you?
Nothing.
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 Right? Nobody teaches you how to be a PA, right? It's like,
Correct.
even though the adjusters and the insurance side, right? They get their adjuster license and teach them how to go inspect property,
Yep.
right? So I have that knowledge and stuff from appraisal. I've just never used my PA license, so I did it for the first time and then got burned on it. So then I'm like, I'll just stay in the appraisal side, and I know I'm missing a big piece, not doing PA stuff. So that
Yeah.
would be basically what you're saying is what that course would do.
I don't believe in appraisal at all.
Yeah, absolutely.
The only time that appraisal is appropriate is if a PA is involved in it. Now, whatever the insured needs to get done to get resolution, because there's only 10,000 PAs and we obviously can't handle every damn claim. But if a PA handled the claim, I don't believe appraisal is appropriate. And it's a very simple thing. You like exactament, correct? I too like exactament, which means that the whole price deal is off the table. We've agreed that we have a price list in place and that we're going to use that price list. So what we can only have a problem on now is two things: coverage or scope. You agreed to coverage or we wouldn't be having the conversation, so that's now out. So now we're talking about scope. That's where my forte is.
Neither one of those are
This is a
definitive
factual
of an
thing.
appraisal, though.
You said you were going to replace the insulation behind that wall. Okay, we've got egress, regress, and ancillary items. Whatever it's going to take to get me in there to get to that insulation, to get back out and to leave this thing exactly like it was before I left. If I touch drywall in this room, what's going to happen? Where's drywall going to be, sir? Every damn where. On the top of the damn covers for the electrical, on the outlet, and it doesn't matter how much we prep, how much we prepare, all of that's doing is mitigating. It's diminishing how much is actually going to get there, but it's going to get there. And what happens when they turn the damn air conditioner on? That sumbitch is sucking it into the vents, and then it's going to throw it all over everywhere else. Yes, all of these items are factual scope items. So if it comes to a point where the insurance company says that we want to go to appraisal, appraisal is inappropriate. We don't disagree on a price, we disagree on exactament. What you're saying is that you want to use appraisal as a baseball bat to get out of paying what you legitimately owe. As a PA, I did my job, and where we're at right now is you're fixing to get sued. And when you get sued, if the judge states, which he often will, hey, you need to go ahead and play that appraisal process out, then something beautiful happens with the appraisal process. It gets done correctly. It gets done inside the bounds of the law. The attorneys are involved, the courts are involved, and there will be no bullshit here. Right? Everything is absolutely structured, and this is something that a lot of them don't talk about, but they should. If the appraisal's in this guy's office, who's paying the appraiser?
He is. The
He
attorney.
is. He will absorb all of those costs in the legal file. And the insured will not be out a single penny, whether they're successful or not. Right? It will come from there. If the umpire is needed, he will pay half of the umpire fee. Now, there's very rare cases where something like that happens. The appraisal is absolutely one of them because it is in litigation. The judge has demanded, hey, this is inside of the policy. The policy says that y'all have to go to appraisal. There must be a hall right there. And y'all go to appraisal, but it's all being done under the color of law. It's all being controlled. I do appraisals for him inside of litigation. If the litigation comes, then I will do them. I don't want to do them out here in the Wild West. Why? Because I have a license that gives me a massive amount of control when I do them in a PA deal. What happens to that authority and control when I go to appraisal? I have none. I'm at the whim of two guys that may, the umpire may want to split the baby. The staff or I or whoever the opposing appraiser for the carrier is may want to keep that stream of income that he's got coming. So he's certainly not going to write an estimate that would go against, even though he knows what it is. Worst damn thing is they always say, well, I'm a builder. Well, you know why you're having to do building and appraisal both? Because you don't know how to fucking charge on either one of them. Yeah. Or you could pick like us, do one thing and do it really, really well. Yes, ma'am.
So you're saying go to suit before appraisal?
Yes.
Well,
Appraisal is binding.
Hold on. If it's appropriate.
Right.
If you as a PA have done your job and their answer is to go to an appraisal, it's too late for appraisal. you're going to get sued. You're going to get a final demand, which will be provided inside of the documents that Melanie showed you how that's done. You'll get a final demand that tells you, hey, you got 72 hours, you should have get off the pot. If you don't, then you're going to get sued. And me, I'm going to go to the next claim. And if the attorneys and the judge decide that your request for appraisal is appropriate, then that's on them and they do whatever they need to do. But we're going to keep moving forward.
And so there's certain attorneys that will take a case, sign it up, and then they dump it into appraisal, right? That's their preferred method.
Hate that.
We're not talking about that. So
we're not doing that shit.
Yeah. No, I'm going to take a case and I'm going to file suit, and we intend to litigate that case. If during the course of that, the insurance company invokes appraisal, we're going to have what's called motion practice back and forth. I'm going to respond to the judge and say, I don't think it's appropriate for these reasons. We have coverage disputes, we have other things that are not going to get resolved through this appraisal process. Sometimes the judge will, after that hearing, will say, you're right, no need to go to appraisal, or they already waived their right to appraisal, and we're not going to make you do that. Sometimes the judge will say, well, go ahead and go through appraisal. It can go through appraisal and get a dollar value while we continue to litigate these coverage issues and these other things going on. So if I'm forced to, that's something I'll pursue, but that's not a preferred method. It's not something we're going to do. I don't like appraisal. Even through litigation, it's a lot more safeguards and protections than the Wild West when you're not in litigation, but it's still not my preferred method to resolve a claim. That's not what we're going to do.
Well, because when it is actually going through appraisal, you only have 20 days to choose the appraiser, period. So if in those 20 days, if you've done your job, you've submitted SPOL, you've fulfilled the contractual obligations under the policy, he needs to get it because he can then make sure it's protected, because time and time again, we all see awards. Those awards don't get paid. If they don't get paid, he then has other legalities that you can go after because they breached that, and he can make sure that that award does get paid. But there's a time and time and time again that they'll tell him to gut the house. One in Louisiana, she got an appraisal. Well, that's a whole nother story, but she got an appraisal and they told her go ahead and gut the house. She gutted the house. It was a rental. They came back after appraisal, $15,000. But then they never paid it.
Card?
So it doesn't matter about any of that. So the second that they went to appraisal, she did what they said to do. And when she actually got done with it, when she actually got done with it, she was still up Schitt's Creek without a paddle. Like literally, she had no protection. She had no anything. And this is also Louisiana, which is the wild, wild west to PA in. If you're not seasoned, I do not advise going to Louisiana. Just saying.
It's about control.
That's a good question too about, the legal process. And so I want to talk just a little bit about when to go legal and when not to go legal. Right? Because I think it makes a big difference. So there's kind of a big effort underway right now, and I'm not a fan of it, but where you see law firms and attorneys are inserting themselves into the claim process early. They're actually going in and they're competing with public adjusters now, right? Under my license, I can do that. It says I can adjust a claim, right? When I do that, I'm putting on my adjuster hat. I'm acting essentially as a public adjuster. I'm becoming a fact witness in the claim. It creates all these potential conflicts of issues later if that claim doesn't get resolved and has to go to litigation, right? Plus, I just think it's going in and it's, competing with public adjusters, it's competing with contractors. I don't think it's a good thing overall for the industry, right? When you start doing that, if you prematurely insert yourself into the claim process as an attorney, guess what's happening on the other side? You lawyered up, they're lawyering up, right? A lot of these claims can get resolved without ever having to need an attorney. There's a right time and place for an attorney, but I like to equate it as a relay race, right? In a relay race, you go out and you run your lap. As you're coming up to that finish line after your first lap, you can hand off that baton, right? You don't have two people running at the same time, except for a very short period of time when that baton's being handed off, right? Attorneys need to stick to their own lane. There's a time and place for it. It's not at the beginning of the claim. I always tell people, get all the money you can out of the claim before it comes to me. Cal and Melanie are really good at maximizing every penny they can get, right? And they should. When it comes to an attorney, there shouldn't be any low-hanging fruit, right? You should have tried to squeeze everything you can out of it, and then it reaches that point where, they've done everything they can do under their license, and they can hand that baton off, right? So every claim has a start and every claim has an end in the adjusting side of things. Two different problems. Handing off that baton too late, you waited too long, or handing it off prematurely. They're both equally as bad. Okay? So if you hand the claim off prematurely, before you fully comply with the policy, before you fully comply with the duties after a loss, right? Now that attorney's having to go back and do everything that you did not do. There's going to be 0% chance of bad faith in that claim because you didn't properly set it up. You didn't try to comply with all the duties after a loss. You didn't try to address each and every issue that came up during that claim process, right? So that's where you just become a glorified case runner for the attorney, right? Let me sign it up today and let me flip it to an attorney a week from now. Typically, with a residential claim, within about 60 to 90 days, you ought to be able to do everything you need to do within that process. There may be some variation. It may go a little bit longer if it's a large claim, commercial claim, or something like that. But that should usually be the timeline you're looking at, right? So you don't want to prematurely hand it off, right? That creates a lot of problems. You don't want to wait too long either, right? If you wait too long and that claim's been active and open for 9 months, 12 months, 15 months, right? Bad things happen to the claim. One, time marches on, life happens, right? The homeowner goes to, sell the home. They don't make proper disclosure, and therefore, because they didn't properly disclose the pending insurance claim and the damages, it makes it very difficult to try to go get any money after the sale of that property. If we have proper notice and we advise them, there's ways you can do that. You can document it, but you have to disclose that to a potential buyer, right? But if the homeowner just goes, puts their house for sale, sells the house, that's going to kill the claim for the most part. People get divorced, right? People move. You're going to have some material change in circumstances that are going to impact the outcome of the claim down the road. Guess what? Weather happens, right? You're over here because you've been holding on and arguing this claim for 18 months, talking about this date of loss, and a new storm comes through and causes more damage to it because the insured's lost faith in you and the process because you've been dragging it out for 18 months. They may go file a new claim. And the insurance company may realize, hey, there's a pending claim for 18 months back here that has a public adjuster involved, but we've got a brand new claim in today with a new claim number, new date of loss, and there is no PA. The insurance company's going to know that when they come out there. And I've seen it time and time again where they go out and they pay for that claim, but you're not part of it, right? Because you don't have a power of attorney on that. You don't have a public adjuster contract on that. That happens. And so there's a time and place on when you should go legal. And there's certain trigger points you want to look for.
And when they go legal, when you get our files, or any of the attorneys get our files, they're only for the dwelling and other structure, correct?
Right.
He doesn't touch any additional coverages. And if y'all are leaving additional coverages on the table, I'm telling you, that money is beautiful.
Yep.
It's absolutely beautiful. But I don't think you've ever, maybe one, Florida, I can think of her name right now.
That's part of our intake process. We always, look at,
What coverages?
Is there business personal property? Is there contents? Is there things like that? But for the most part, I'm riding the horse that you've already been riding, right?
Yeah.
You've already opened up coverage. You've already staked out a position. You've already submitted that proof of loss. We're locked into that damage model you've created,
Yeah.
For better or for worse. A lot of times, you've done a great job doing it. But if you didn't open up other coverages, pursue other coverages, right? Later down the road, we may have an opportunity to try to bring that back in. But if we're raising that for the very first time, 18 months after the claim's been filed, a lot of times it's too little too late.
And they're definitely not flood claims because flood must be submitted all together at one time. You can't not affect a single coverage that you plan on affecting. It has to all be submitted at the same exact time.
Right.
So flood's different, flood's federal.
I hate
A lot of, we do, we take flood, but the flood needs help too. I do all of my flood certifications every year when I do my CEs because we're gonna take them. Like, nobody else wants to take them, so we're gonna take them.
But we're not
we know the
spending no
standard.
ad dollars on getting flood claims.
No,
I'll tell you that right
no,
now.
no,
But I
no.
think this should be the model.
And
We
attorneys
don't want the
want
flood
'em.
claims, but we're not turning any legitimate flood claims away.
No.
It's like the attorneys that tell you they don't want to take your small claims. I guarantee you, if you got shit claims, they're not taking them no matter what.
Nope.
If you got a Walmart bag that you pull up to them and I see it all the time, and hell, I used to be that guy before I met this wonderful woman here. You take a Walmart bag to them and you tell them, I got clear bad faith right here. Here's my proof. If it's a small claim, he's going to spend 3 or 4 hours, and his office is going to spend 3 or 4 hours straightening up your paperwork and putting everything to where he can even see if you're even talking to the right person.
Yep.
Do you even have a contract signed by the person that is legally able to sign the contract? And oftentimes that answer is no. Means I've spent all of this time for nothing and I don't know what you have. Now you take that in opposition to somebody that has a claim file that you go, here, click this button. You click that button and pap, here comes everything that you've done. Complaints that you filed, the contract that you signed, the deck pages, everything that's on that damn claim. It doesn't matter if it's small or not. He knows immediately whether he wants to take that claim or not. And if you, who have a lot of power but don't realize that you have power. Shaun is one of the best men I've ever met in my life. And I don't say that lightly. I've met a lot of people. I know a ton of people. I do a lot of business.
I'm going to crawl under the table here.
No, your morals and ethics.
His morals
You've
and
never-
ethics are such
you've
that
never
what he's
wavered.
telling you right now is that he wants you to go get every damn penny out of that claim that you can get before he puts his hand on it. Do you understand what that means?
Protect the insured.
He is foregoing his percentage on that money and telling you to go do your fucking job. Do it. Get every penny that you can, and I don't want to see it until you have done so. Then when you have done so, you have truly given the insurance company every opportunity to do the right thing, and they have absolutely failed. And because of that failure, I want to take them into account. I want them to do what the law requires them to do and what the contract they put promised. But first, you go get all of that money. What you're really seeing is control. See, we took control away from them on every aspect of that damn claim. The only thing they now have control of is what the contract gave them the control of, and it's whether or not they pay it. And if they don't pay it, then there has to be a consequence for them, and it has to happen quickly. You get an engineer's report, and it's 120 pages of shit saying that we don't pay. And you don't respond to that engineer's report. Shaun doesn't have the luxury of responding for you. The response has to come directly from you, and it has to come right after it occurred. They can't get the trial, and then you bring out the engineer's report, and it's a straight farce. And if you'd have ever looked at it, you'd have got past that second page where that beautiful stamp is at, and you looked at it, you'd have went, this shit doesn't even make logical sense. But you didn't say that in writing, and you didn't put a rebuttal to the insurance company. So when the insurance company gets it, and Shaun says something, this is a bunch of shit, yes, that holds some weight. But if you thought it was no good, why didn't you say something then? And the insurance company could have had an opportunity to have listened to your opinion and said, you know what, you're right.
This is such a
That
big
guy
deal.
is an idiot. We're sorry that we sent him out there, which they can absolutely say at trial that you didn't give them the opportunity, and they would have changed their mind. If you gave the opportunity at the point of impact and they refused to change their mind, but you gave them that damning information that told them that their report was full of shit. You didn't just say it was full of crap. You literally tore it apart. He says this here, this is absolutely untrue. He calls the product a slate product. It's actually concrete barrel tile. He don't even have, you point these things out, he then has something to work with. If you don't, you've lost control, and you've given control back to the people who don't deserve to have it.
So people call me up all the time and are like, I got a great case, clear bad faith. I'm like,
Clear.
Clear bad faith. Bad faith on a platter. Wonderful. That's great. Whatever the issue is, did you bring it to the attention of the insurance company and try to get them to do the right thing?
What?
Well, no. I'm just going to give them enough rope and they're going to hang themselves. They don't even know they stepped in it yet, but then you can come in and you can slam them, right? When I get to trial, they can just say, oh, I'm sorry. We had a misunderstanding. To go after bad faith, I have to show that they did something knowingly or intentionally. And if you didn't call them out on it, you didn't try to get them to do the right thing, and they double down on it, they have that as an excuse every time.
It's their best excuse. Nobody told us.
Right? Oh, nobody told me. You didn't call me out on that. If that was an issue, why didn't you bring it up, 9 months ago? when
We
this was
would have
going
done the
on?
right thing because we're an honorable company. If you
You
would have
didn't
just
give
brought
us
that
that
to our
consideration.
attention, we would have.
And if I can go back and say, well, look at this email from June 15th, right? Look at this complaint that was filed. Look at this follow-up phone call with the call notes here. They try to get this issue resolved not once, twice, 3 times.
Done?
Are we in litigation because we wanted to be in litigation? No. We're in litigation because we had no other choice. The public adjuster did everything they could to try to resolve the claim. And you just double down, you triple down on your position time and time again, right? You kept committing the bad faith. You kept putting that lie out there. So documentation is key, right? And if it's coming to an attorney where, oh, they committed great bad faith, but I'm not going to call them out on it, then it doesn't need to go to an attorney. You haven't complied with your job. You haven't finished running your race yet.
But did you document it?
Yeah.
Because if you didn't, it's hearsay. And
Yeah.
how admissible is hearsay?
Huh?
How admissible is hearsay?
If you have the documentation, it's admissible. It's a business record.
Yep.
If you don't have the documentation,
Do you do inspections for your company?
it didn't happen.
And what she's talking about, what they're specifically talking about is you go out and the adjuster tells you, hey, man, you're right, that is hail damage, and this son of a bitch is covered. And then he goes back to his truck. You go your separate way. Later on that afternoon, you get a full denial. Same son of a bitch. Okay, what she's talking about right now is there's 2 different things that could happen. You could say that guy told you there was coverage.
Hearsay.
Or you could have your assignment sheet that you go out with everyone and you write every damn thing that happens down on this.
Business record.
And this becomes a business record. Okay, and this is something that you do when? Every single
During
inspection, you do it
The time,
exactly
act,
the same.
event, opinions herein by a person of knowledge above those acts, events, opinions therein.
But what you're doing is you're creating a trail. And you're creating a pattern of things that you do. You do this every time. We shouldn't see, I have new guys that come to work and they bring me the appointment checklist and it's beautiful. Penmanship is off the chart, clean. And I'm furious and they're looking at me like, why are you mad? No. This should be ugly. It should have scribble on it. I should see the sweat marks from your brow because it's a hot son of a bitch out there, which means that you did it when?
During.
In the process. It's not a memory thing. Memory thing is the thing that'll kill you, things that you do from memory. You wrote this down in real time and you put it, and you do it every time. That goes from beyond being hearsay to being a business record, which means that Shaun can then bring it in as an exhibit into evidence and it's absolutely acceptable. Right? And then another thing to do is to memorialize it just as soon as you walk off. Shoot them an email. Hey, thanks for confirming coverage and that was hail damage. But the main one is that your assignment checklist, your adjuster appointment checklist, be done every single time and you be 140% honest. If you were late, then it should be the first damn comment on there, I was late. If you put a sheetrock on there when it should have been plaster, it should be all of your faults and failures as well as any that they make. Right? Mr. Adjuster, did you read this policy before you came out here? Well, yeah. You read the whole policy and they see what you're doing. Wait a minute. I read the exclusions and, you get a different response and you get a truer response because of what you're doing. Scares the shit out of them.
Reputation will
Nobody
precede you.
does it. Nobody gets out there and holds them to the candle. And how many people tell the insurance company they're going to sue them? Damn near everybody. How many actually does it? About 4%.
She had a question.
And I'd say that's probably a very liberal number at 4%. Who had a question?
Yes, ma'am.
Yes, ma'am.
So when you do your sheet that you're talking about on site, can they counter and act like that you didn't do that on site and that they didn't say those things?
Well, yes.
Of course they do.
Yes, but that's what makes
Like
it.
a rug, they do.
Have more weight.
Because that makes it business record, it's not hearsay. If you don't actually document everything on site, everything in our company is done pretty much by the office, They write the estimates, we uphold
Public
their
attesting is
estimates.
80% office.
Then they go back out and do that mutual inspection. That was the only part in all of our hundreds and hundreds of depositions. That's the only part that was getting questioned because it wasn't business record. Because I can't do it. I can't document it. I'm not the one on site. Sometimes I was, but we don't do that anymore. So they have to document it. And what I do, they immediately take a snapshot. They send it to the office upon leaving property, which is then starts a lot of things in the office. We tell the insured your premise is secured. We then follow up with the desk adjuster because our argument isn't with that field. That field wants to write as valid as possible because they are paid on a fee schedule as well.
Most of
Anything over 25,000, they get 250, 500, all that. So they want to pay proper. But like Allstate, we all have seen it, we've all heard it. Oh, it must be torn, creased, or missing in order to consider it wind damage. Immediately memorialize that to the desk, and that's not in the policy. And they're going to stop immediately. They're not even going to address that it was said, but you're going to get a different adjuster, and you're going to get a fair adjuster. More times than not, what they're at, they're
Fair, huh?
The field tries to be fair, or you're going to get do not engage, and you're going to walk on
That's
site.
what they tell them with me. Do not
And they're
engage
like, oh,
with
we
your
thought we
phone."
were, we thought we were meeting Melanie one. They don't ask me who's meeting, and we go through all of this in class, but we didn't know who we were meeting. That's not my problem. You didn't set your file up correctly. I did mine.
Doesn't matter.
So
Yeah.
when it goes to him and then he's on site, sometimes they're prefaced and company meetings start with do not engage. Do not engage with insurancebusters.net. They are documenting every single thing you do. It has to be. You can't do the mobile home and halfway document it and then go to the complex and then you did document that one thoroughly. But it also gives you, if you're doing 5 back-to-back one day and y'all do it, you will literally go from one job, and that's what you're doing is your mutual inspections. You have to do it during the acts, opinions, and all the conditions, everything by a person of knowledge of all of that. So if that's not done, you can't prove business record. He can't uphold that for you. Or the insured, because he's not our attorney. He's the insured's attorney only. We are
Don't tie his
unrepresented.
damn hands before he ever gets started.
But
is
if
what
you
we're
don't do
saying.
your job,
Yeah.
y'all better have your E&O in place. Because if you sit on that claim and you don't move that claim with statute of limitation timelines as well, they can come after your E&O.
And the
So-
carriers are getting good about going back to these clients where they saw that there was an issue that the PA did or that the contractor did. The other side is getting good at going and talking to those people and getting them to file suits and shit against those people with the full benefit of the carrier's machine behind them.
And as I feel that's rightfully so, I really don't because they are trying to do their best. There is no school out here that teaches us how to do our job. None, besides us. And I'm
What
not,
was I saying, Shaun?
So you want your contemporaneous notes, those field notes you're writing down, but then you're also going to follow up with emails. You're going to follow up, so it becomes layered documentation, right? And so you're giving them that opportunity to resolve that issue, right? If that wasn't true, what you put in the email, they should have responded right then and there, and then you could have got down to the essence of what the disagreement is, right? If they didn't, right,
it's fact.
a non-response is a response, right? They had the opportunity to call them out, correct the action. They chose not to. That's going down as, this is the record of what happened then.
Yep. So I am number one. My argument's with the desk. His argument's with the field. You normally, the desk is the one that accepts or denies and extends coverages. We all know that. That's what they say.
Until it gets heavy.
Use
then when
all
gets
of
heavy,
it
I get
back against them. If I CC him in an email, he knows that I'm done because I don't argue. I'm not going to argue.
My name is Cal Spoon.
I've
I'm now
called you an
taking control
asshole
of
and
this
I've hung
claim.
up
It's
on
not a
you,
good thing
but
you
guess
wanna
what?
hear.
It's in my record. I have said MS called him an asshole and hung up on him. I've done it before. I've done it numerous times. I don't have verbal conversations because I don't do well with verbal conversations. My stupidity and ignorance levels are, they're not there. So if I CC him in an email, he knows that I'm done. I'm not, it's fixing to get nasty, so he then takes over. Hi, my name is Cal
But
Spoon.
every organization should have the hammer. You know,
So-
there's a day-to-day thing that goes on that everybody handles, and then there's a hammer that walks in when things get out of control, that walks in and calmly, collectively puts them back into perspective for
Or
everybody.
stops it entirely.
Yeah.
So, But yeah, you have to document it, and more times than not, whatever, if he's on site and you're the one following up desk-wise with his file, then that desk is going to either immediately reply, reschedule you, because what you just put in writing is now record. And if they don't counter that, that becomes facts. It's all support, every single bit of it, business record, but did
Who
you
likes to
document
have
it?
control? That's what we are talking about right now, is having control. Putting the control inside of your hands for what you do with your business. That's what they got really good at, is taking away the control from everybody. Name me any other business or transactions where you routinely go and sign a contract for an amount of money that you have no idea what it's going to be. That's not good business, is it? But the entirety of the insurance restoration world works just under that premise. The insured signs into a contract with the contractor that they have no idea how much is going to be paid, what's going to be corrected, what's not. A contractor signs that agreement with the insured, not having any idea any more than the insured does about what's going to be paid. In what world does that make good logical sense? Creates a big old gray area, doesn't it? How can any business operate off of that gray area?
It should be black and white for us.
They cannot. That's why 95% of the contractors go out of business. That gray area absolutely annihilates them. When you take control back of that, you change the dynamics. While we can't tell when we're going to get paid, we know roughly what we're going to get paid. Right? We've done this a whole bunch of times. What I put down was factual, correct? What Shaun does is factual. What he does is the same thing that we does. He goes after everything that is legitimate in there. Things that are questionable, we don't mess with. If you're down on your hands and knees looking for hell, get up. Get up from there. Go some damn where else. Do not throw shit on the wall, hoping that enough of it is going to fall down that you make enough to get the job. That's never going to work either. The entire industry is big, but it's very small. If you're the guy that throws shit on the wall, you're known across the aisle as the guy that throws shit on the wall and will take less. We have another word for that. What do we call it? Fraud. Making demands for things that don't exist. As a PA, you'll go to jail for fraud. Right? So if we're that heavily regulated, everybody is looking at our stuff, the product that we come out with should be what? Solid.
Meticulous OCD.
Should be solid.
Very.
Right? And you should be able to stand on that thing and defend that thing.
Line item by line
When you
item.
get really good at that, then they go after them. They go after the white letter of what's going on. And they want to get you on an administrative thing and not on something that you did because they can't find fault with it. So they're going to look for every avenue, and your documentation better be to a damn point that you don't get tripped up simply because you were not in compliance.
Yep.
It is crucial. The administrative portion takes up about 80% of what public adjusting is. As the guys, most of us that are, we're in the field, we think we got it hard. We go out there and we do some estimates and we do all of this shit. 20% of what's going on in that office. The office is handling everything else. We have it really sweet where we go out, we do the adjustment. We come back in, we do the estimate. We do any follow-up. The office does 80% of everything that's going on. They do the intake. They make sure all of everything that the insured is supposed to have is there.
Policy
they file
review.
the complaints. They file the final demands. They take care of that entire thing while we get to go out and estimate. Office is 80% minimum. When I hear people say the back office, I know you don't understand. It's like saying that you didn't submit an SPOL, but you got clear bad faith. Bless your heart. Bless your heart, you just don't quite understand, do you?
If you don't business record everything, no matter what claim is, then it'll never be admissible. It'll never get to defense. It'll never get to plaintiff, anything. That will never be able to be reached for a good settlement for that insured. And going above and beyond is our job. We need to build it ripe for litigation. You two use that word so much, I've started using it.
Because it's
Make
correct.
it ripe for litigation, because if he can go above and beyond, and that insured is paying 20 to 40%, depending on the attorney and the attorney contract, and then they're paying our fee as well, Is it really worth going to an attorney for very minimal money?
For 65% of what you wrote anyway?
No. Like, you have to do your job. You have to build the file. You have to document it, because if you didn't document it, it's hearsay, and that's not admissible. So you have to get everything done correctly so he can properly do his job.
You got to prepare every file like it's going to war. Right?
Every single one from day of
And
contact.
then hope for peace, right?
Yep.
If you build your files like that, more of them are going to resolve and not need an attorney, as opposed to the ones where you have to ask to do the job, right? And those are the ones you try to dump into litigation.
Well, and tell the
because the insurance
insured.
company's not going to pay because you never forced them.
Yeah, and tell the insured their expectations and what the possibilities. Tell them the worst
From the onset.
and work on the best from the get-go.
So I'm a PA, and I do most of my stuff all from the desk. And a lot of what I do is over the phone. What I like to do is, like, when I have a conversation with an adjuster, they say some things, they agree with some things, put it in an email, like,
Yep.
hey, this is
Yep.
what we
Yep.
discussed. That would be, like, admissible as, like, business notes or whatever. you're
Well, you
saying,
documented it. During our conversation, we agreed that this and this and this and this and this. If they don't come back at that, then they're not contesting what you said, so that does make it business record, but you can't do it that one time. You have to do it every single
Consistency is
time.
key.
Right, exactly. And because a lot of times they'll be like, yeah, I fully agree, what you're saying is right, gotta run it past management, and then management comes back and says.
Gotta run it past
"Absolutely not."
management.
Yeah.
But I
So-
have those notes as email, in an email chain.
And then my response to that one after the supervisor was, your assigned adjuster not competent to do the duty set forth? Because, I mean, you put him in that position. We're
It's a valid
friends. Me
question,
and the
yes.
carriers are best friends. They love me. Absolutely love me. But you put this guy in this position that obviously you thought was capable, and you made the agreements, but then we have the pencil pusher that never sees the job site. And that's the one
Bean
that cuts
counter.
the check. So that's where your argument is with that desk supervisor. You have multiple different IA categories. The argument isn't with the field, it is with the desk, and you have to document every single thing, mainly that on-site inspection, because in a deposition, if they can shut that on-site inspection down, that invalidates and shuts down that SPOL. That's the whole reason we're here.
Who does your field stuff?
With the guy that was sitting.
There.
Yeah.
So everybody knows what they're doing, and when you attest there has to be inside of your organization a level of trust. You have to be 100%, it has to be a literal gear, where every single piece of that gear is in the exact right spot, so when it turns, everything goes the way that it's supposed to go. Which means if you can attest that your guy knows what he's doing, and that your argument is strong inside of there, then you've got that wheel. You have a whole wheel where you can get a whole revolution out of that thing, and that's the ultimate goal, is to get a full revolution out of every turn.
Right, because the guy in the field, he writes his paper, right?
Right.
Uploads it into the file. So
Yep.
I have that to go off of as
Yep.
well. Now I have that, I have pictures, I have everything,
Yep.
and then, I do my emails, my estimate and everything.
And then
But
you
I
desk
make a lot
adjust.
of phone calls.
And then you
So I
desk
follow them
adjust.
up with, hey, per our conversation, this is what we discussed. So
Right.
all of that can be
So
used.
Yeah.
that phone call is the hearsay element of it, right? When you write the email, it's no longer hearsay. Because now you have a written correspondence about that.
They don't respond and say, hey, that's not what we discussed.
Then that's the facts of the case.
Okay, cool. That's.
They have to contradict it. And if you don't, great.
Becomes the truth. But
yeah.
that's true to both parties. If they say stuff to you and you don't respond to it,
Thank
then
you
you're
for your
literally in
approval
their
of the
spot.
submitted SPOL. We expect payment within such and such days. When you say approval of SPOL, they're going to reply, we do not agree. You're going to get a response. There's certain language
just
that I
gonna
will
send a check.
teach you
Yeah.
all week long that will immediately get you responses.
Let me ask you a quick question. So what about when I inherit the claim, say it's sure, they've obviously already got an engineer out, they know every claim. Does my proof of loss report with my inspection report act as a counter to that engineer report? Or should I go through?
No, should be separate. You should go in there and tear his shit up.
Even though it predated my
Absolutely. It's a different deal. They brought in different information that they didn't give you before, and you should absolutely address that. You should address it quickly, and you should do it with extreme prejudice. Especially when they do shit like, well, there was hail damage out there, but it was not functional. Or it was damage of a cosmetic nature. Are those engineer words or are those policy exclusion words? And where the hell did you get them at? Why are you using, you had one job out here to do. Tell us whether or not the covered peril damaged the covered property. It's really a yes or a no question. Mechanical damage, show me a roof that doesn't have a mechanical damage. It's improperly installed. Show me a roof that's 100% properly installed. Show me one.
You insured it. You took premiums on it.
Well, those things are not relevant. Yeah, you're talking about things that don't have anything to do with what we're here to do today. Did the covered peril cause damage to the covered property, yes or no? If you agree that it did, then you get out of here because your license doesn't allow you to do anything. For instance, they say the engineer comes out and he says, hey, this metal panel is damaged. This single metal panel is damaged, and we can replace this and make everything okay. Okay, you should have stopped when you said that it was damaged. Now the policy is going to take over, and we're going to ask a simple question. Did I have a patch on this frickin' roof before this started? No, see, that's not an engineer question, that's a policy question, which means that you told us what you needed. We have direct physical damage. Then the policy steps in to tell us what the proper repair is. Repair or replace, whichever does what? Restores us to pre-loss condition. If I didn't have a frickin' patch on here before, I better not have one after, because that does not, well, it's an old roof. I agree. That's why we have depreciation. We're going to account for the fact that the roof is 10 years old. You're going to immediately depreciate it, and it has nothing to do with the process with which we're going to get to it. The repair does not return me to pre-loss condition, so replacement is the answer, minus any correct deductibles, depreciation.
We were talking about the proof of losses and submitting, and then new information being presented, amended, resubmitted for proof of loss.
Revisions on your SPOL?
Yeah.
Okay.
Initial proof of loss is filed when the claim is filed, right? You dropped up what you believe is the worst case scenario for this loss per policy condition.
You look just like that actor. That's been killing me. What's his name?
What actor?
Yeah, he looks like one of the actors. I mean, you're a damn ringer for it. I'm going to find that guy.
Okay.
When you talk, I just look at it and I think of that guy.
Thank you.
Yeah, he was a good actor. I can't remember what his name was.
Because what we have found is no claim is static. They're ever evolving, more information is presented. There's statute timelines that are triggered when the proof of loss is submitted.
Yes.
The submission of multiple proofs of losses, like figuring out when to submit it, and then what information is provided, and if that continues to extend those timelines for the carrier,
So you're creating a new timeline just for that incremental part that you're adding in for the very first time. Okay, so if you wrote the proof of loss for $250,000 and you went back out and you realized, hey, it's not $250, it's $265. There's some components I left out of that, right? And you're submitting a revised proof of loss for that. For that $15,000, for that scope of work that's associated with that, you're putting the insurance company on notice for the very first time of that. And so they have a new time clock as that's involved. The prior scope of work, the $250,000 has already been submitted. It doesn't restart the clock on that, right? Nothing changed from A to B, right? Except for that increase right there, that $15,000 scope.
That would include engineer reports and stuff like that?
Yeah, I mean, anytime you feel like, and you should, right? I mean, you want to make sure that when you're submitting the proof of loss, you believe it's accurate, right? You're not prematurely submitting it. You think you have a complete and full understanding of what the damage is. But things happen, right? You realize there's something else damaged. You do a reinspection. You identify additional items, right? Correct that, right? You want to resolve that issue as soon as you can. And so you're doing the proper thing, but it's not restarting the clock all over again. It's like, oh, I had them on the clock and they only had 2 days left. Now I got to submit this, and they start getting, no, don't worry about that, right? It's just for that incremental difference there.
What we're talking about is why statute of limitations exists. Right? That's why the statute of limitations is there, is for us to be able to go in and include additional items that was hidden from us to begin with. Okay, you take a car in and they see that the front rim has been damaged. We don't know what's underneath that until we tear the car down. That's what it allows us to go in there and do the initial assessment of all the known damages. You should never be, give you a straight up example. We have a set of kitchen cabinets. The cabinets are damaged, so we got to take the cabinets out and replace the cabinets. What do we do with the Formica top? What'd you say? That's correct. Why do we not replace it? Because if it's installed right, it's going to break when it's coming off. But why aren't we replacing it now?
We don't know, it's not.
Because the son of a bitch ain't broke now. Right? We're doing it for what's factual, not what we believe to be happening. So your SPOL should reflect what is actual here. If that thing breaks, that is an absolute supplemental item that statute of limitations, that's the whole point of it. You go in and start doing it. We have the ability to go back and get it covered. We couldn't charge for it in the beginning because the son of a bitch wasn't broke yet. But there's pretty good odds. How many of y'all have ever installed Formica countertops? If that thing's installed right, it's going to come off in pieces. It's not coming off in one deal. But it hasn't happened yet. So we can only demand reasonably the items that we know 100% are damaged and are what's going to need to be paid for. We can address it as being a detach and reset, and you can even put a little note in there. I believe this son of a bitch is going to break, but it hasn't, so we have it in for detach and reset now. Come on in. Mm-hmm. Come on down. Hello, Mr. Osteen.
Yes.
How are you doing?
Doing great.
Is it Mrs. Osteen?
Yes.
Fantastic.
Hi,
Congratulations
nice to meet
on that deal. Hello, young man. How are you doing? Good to see you. Questions?
Questions, comments, concerns?
So when can you open up those other coverages? I know you mentioned.
I do additional coverages. Yeah, the guys do dwelling and other structure. I do additional coverages. If it's flood, you have to do it immediately. When you submit the dwelling and the estimate, you have to submit all additional coverages as well. But you open up additional coverages immediately. That's how you start getting the money coming, because they'll argue on the dwelling and other structure, but you can get loss of use, loss of rents, personal property, mortgage protection. You can get all of those immediately paid.
You want to get money flowing as soon as you can.
Yeah.
All of it.
You can't estimate for if you don't know the cost at that point.
For what?
Additional coverages it's not a cost.
If you have the SPOL
Yeah,
down,
you
you
can.
should know
You go and you get the valuation, you tell the insured to get their lease, let me get it approved by the carrier. Once the carrier approves it, you submit it for 6 months, they're gonna kick it back and give you 3. Every single time.
And then supplement the rest, right?
Yeah, but I'd rather visit it every 75, 80 days rather than every 20, 25. So I'm gonna push it out for 6 months, and then we're gonna kick it back, and they're gonna do 3 months, but additional living every single time. Loss of rents, you get the leases, you get all of the tax records, you get all of that stuff, you start generating that money.
So you're gonna put that all in your initial.
Yeah, but if you submit, no matter which one you submit, you have to let the carrier know that you will be visiting those coverages.
Same with an
Think of it as a
engineer.
flow chart.
Same as an engineer report. I mean, we haven't hired an engineer yet, but we know.
You as a public adjuster?
We need one,
You as a public adjuster?
correct.
You should not be bringing an engineer.
Well, I thought we'd have to pay for that.
Exactly. Why are you going to waste that overhead?
or you're going to end up transferring it over to the deal. If an
Yeah.
engineer needs to be done, let them bring the engineer.
Tell
You
them.
beat the shit out of the engineer. That way, when he gets it, he's going to have to hire another engineer.
Yep.
So the insured would effectively be paying for your engineer
That they're not going to
that
honor.
nobody's going to mess with. And if
Nope.
it goes to litigation, which it is, that's why you've got the engineer involved. Then when it goes to litigation, then the attorney, no matter who it is going to have to bring another engineer who is going to be expected to pay for each one of these engineers.
So you should absolutely go through and tear apart any engineer report they produce,
Yes.
right? As a critique and a response. Is hiring an engineer going to move the needle one way or the other? Is the insurance company going to come out and say, you know what? We like your engineer, we don't like our engineer now. Your guy's smarter than our engineer is. No.
Now, there's instances I think that you may be getting to now where you may have a mutual
Right.
benefit, and we have one that I'm going to leave and go see tomorrow where we've done our estimate, but I've also have a $2,500 charge in there beforehand to bring that engineer to verify what we've done.
So if you're dealing with structural issues,
Yes.
right, there may be a time and place to bring an engineer in. If you're bringing an engineer in, just as an arms race, they have an engineer, let me get an engineer, don't do that.
No, you should submit your SPOL, and when you submit it, let them know, hey, we need an engineer. Well, why do we need an engineer? Structure might be compromised. they deny it at that time, what you're gonna get is once you get off that job site, the desk is gonna come back and say, oh, we need an engineer.
Do I do the, say I have foundation damage, do I, and I know we're gonna, do I go ahead and estimate for that damage?
Yes, and put them on notice and
Hold on,
say,
lady.
bring your people.
Say the rest of it.
Do I go ahead and estimate for the damage myself?
What I would say is that if I look at the foundation and the foundation is damaged, and the ideal is that to get to the foundation, what's going to happen? I don't need an engineer for that. Yeah, the foundation's damaged, right? Huh?
The foundation's broken.
Right. How are you gonna get the foundation corrected?
Take it off.
Reframe.
Take it off.
You're gonna pull that house. I call it a house off when I do the whole thing, but typically the house would have to come off of it, and the foundation would have to be done. Huh?
Well, I don't know what.
Attach and reset house. That's it.
So if you don't, okay, let me hold on. If you don't know what the correct repair method is that what you're saying? You're not quite sure. Okay, then what you're doing is you, my friend, need some help, and you're going to hire that, and you're going to pay for that out of your pocket. That's part of your education.
Yeah.
Nobody else should be paying that. You don't have the tools to put together what you need to put together. So you're paying this as part of your fee, just like you would pay an adjuster to adjust something you didn't know how to
But
adjust.
they could send their engineer out.
And they
with
will.
recommendations.
And they will, for a professional denial every single time.
That engineer that's coming out for the insurance company who
It's a
they work
professional
for.
He's got a
denial.
different set of rules than you do. Yeah.
I mean, it's, they're gonna have to follow code too, and.
They don't.
Uh-huh.
They don't.
They're supposed to. That's where the final
But
debate.
nobody ever says anything to them. That's why I'm harping on you have to go after them, because they'll put shit in there that's completely not code, not anything else.
And-
But nobody ever looks. If nobody ever calls them down to it, they do. We got one guy that's a engineer that literally, I use his report in camp. We go over it, we tear it apart. We've had two other students who had this same fucking engineer, and we pulled up his report, and lo and behold, what do we see?
Identical.
Verbatim.
Yeah.
Verbatim. Same damn report from this guy. But your question's kind of multi-tiered. If you yourself don't know what's going on, then you need to bring an engineer out for you, not for anybody else, and the insured not be paying for it. You'll never bring an engineer on that again. That's your part of your education. If there is a problem that you don't know what's going on because you can't see it, that's the issue that we're in tomorrow. There's a collapse from the ice. We know automatically that these things are going to happen. We have them in the SPOL. I also included a $2,500 charge for us to mutually agree. You can bring your engineer, I can bring mine, it doesn't make a shit, but we need somebody to come out here and say that what we're doing is correct and that we don't need to go further. And I don't care which one does it. They just better tell the truth.
And as public adjusters, we need to submit, we're not IAs right for seeing damages. You know what it takes construction-wise, y'all do. Know what it takes construction-wise, and if you don't, then bring those people.
Most of the
Get
time
it.
that alleviates everything. Is that what
Mentor
she's
it.
saying right there? You knowing what the proper method is to, if it's got to be, like if the foundation has to come out, then there's really no other question about what's going on. The foundation has to come out. Then we would do egress and regress to get there. Right? How does the foundation come out? Well, you got to take the damn house off. If that's the proper method.
Yeah, I don't know if, engineer would total loss of the house over that or not.
And
No, they'll
engineers
just
are
give
funny
their,
too. They
they'll
get real
just give
scary.
their causation and conclusion. But if you bring it, they're gonna err on your side because you're paying them. If they bring them, they're gonna err on their side because they're paying them. The insured's asked, why are they
shouldn't,
bringing
but
an
they
engineer?
typically do.
There's
Yeah.
a
For a
big
professional
discrepancy
denial.
between the repairs and a total loss.
Correct. There's two different total losses as well.
So how do you put that into the initial proof of loss? Build that in.
You just write the
Keep
estimate.
writing. All of
Okay,
it.
Supplement it, so you,
Hopefully
why-
write it, all of it the very first time so you're not revising SPOLs and changing the timelines.
so would I delay, submitting the proof of
Yeah.
loss until I had my engineer?
Yeah,
report?
if that's
You
what
can
you
submit
need, yeah.
partial proof of loss, and I would suggest that you do. Get the flow moving. Do all of the known things that you have,
That's 100% what I-
right? And then leave an asterisk at the very top of that report that you're putting in if there's additional damages, but you can't access them. And then put why.
Yeah.
Typically, I would add a charge like for tomorrow. We put $2,500 in there for you to pay the engineer, and I don't give a shit who hires him. Right? You have a stamp, and I expect that because you have that stamp that you're going to come out and do the honest thing. If you don't, then I'm going to tear your ass up.
Yep.
But the difference is I know what you're supposed to be doing. I simply need you to come out here and affirm to it or prove me that I'm wrong. But I'm not trying to get you to come out here and go against what the insurance company's already said. That's a losing battle. They're never, that I've ever seen in this whole entire career that I've been doing, come out and looked at my engineer that I brought out after theirs and said, you know what, your guy's right.
They're not gonna honor
My
our
guy's an
report.
idiot. We're going to pay based on what your guy said. No, they're going to say, no, we're going to stay with what Homeboy said.
I just had one.
What? Where they agreed with yours?
Good.
That's fantastic. That's like a
Fabulous.
unicorn.
Good.
You should frame it, put it in a picture, and put it up with the lights
But
on it and stuff.
Normally, it's a waste of overhead because they won't honor their report.
Say that again.
Yeah, exactly. We request.
Have you dealt with that insurance company multiple times?
No.
First time you've dealt with them? That's a bonus. I
Sounds
would
like
take that as a
farmers.
win all day. Yeah.
USAA too.
Yeah. Which with what?
USAA.
USAA.
Yeah. They've taken a big wallop here in about the last 6-7 years. They brought the Allstate guy over and they did horrible. USAA has nothing to do with the military.
USAA used to never
Yeah.
hit our books until about 7 to 10 years ago. And then we started taking USAA because they did good. They did.
And then they hired that guy and they went to total shit. Yes. Questions?
Yes, sir.
Is there never a time that a PA should submit a formal reservation of rights letter?
You have it on your opening and closing statements that you received in your class.
So
I provided to you on Thursday.
Yes, so let's say they have 90 days to make a claim decision, and on day 89, they say they need to bring the engineer. Is it assumed that we're still abiding?
Investigating?
Or-
You should have brought that guy a long time ago. That doesn't extend any timelines.
No.
So do you
Yeah.
have to formally say that, or just assume that because the reservation of rights was on the first notice to insurance company, that it's...
Okay.
So I have language that I provide everybody in class because a reservation of rights doesn't create any new rights, right? That just
reserves.
means, hey, we're reserving any and all rights we have. We're maintaining the equilibrium right here with our position, right? So, yeah, I think there's a time and place where you need to, in an email, respond back. If they're intending to violate the timelines, right, we'll provide you access. Even if you choose to come out after the timeline, you have to accept or reject this claim. However, by doing so, it's strictly just to provide access. We're not agreeing there's an extension, or it's reasonable, or additional time is needed, any of those things, right? We're reserving the rights under the statutory law for any failure to properly and timely pay the claim.
Typically what they will do is say that we send in the SPOL. Okay, and in Texas, they've got 15 business days to investigate. Say they wait till the 14th day and they contact the office and they say, hey, you know what? Or even worse, we get out there on inspection. And the first thing the guy walks out and says, you know, I just noticed that you have a complete roof on here. We're going to have to call the engineer out. Okay, my response to them is very quick. You got 24 hours to get it done. You have 15 business days to get the engineer out here. Okay? Tomorrow is the 15th business day. You got the SPOL 15 business days ago. If you wanted an engineer, the reasonable time, well, we didn't see. That means you didn't review every document that the insured sent you? Is that what you're telling me? It's exactly what you're telling me. It's either that or you chose to wait till the last minute. Either way, neither one of those extends the time limit. So we will, as Shaun said, facilitate meeting them out there. But you can guarantee that if you don't have your shit done tomorrow and have what we need, the office is going to file a complaint on you for not finishing the investigation within the 15 business days.
And for one, I told you you needed an engineer 15 business days ago.
Or you don't need one that you're pulling shit. The SPOL told you what we intended to do. Whether you reviewed it or not is on you. Whether you reviewed it and decided that you would push it off and wait, that's on them. And if they don't, it's up to us to file that complaint, and they quit doing it. Yeah, that used to be a ploy of theirs to get time. Well, now we've got to take an engineer. You do what you need to do. You know what we're going to do? Same thing.
Your procrastination doesn't create an emergency on our end, right?
And they didn't ask for an extension, which you can't really give extensions.
The extension has to be something that is
reasonable in light of the facts.
The racetrack. We did Pinwheel out in Odessa. Okay, everything on there is pretty standard until you get to one thing. The damn timing system.
Oh.
There's only one person in the entire world that has any idea what that timing system is, and it's attached from the actual control module all the way down to the damn tree.
Yeah.
where the light is at, and only one guy can do that. That would be reasonable for us to take some additional time on that. But all of these other day items that we deal with the other day, you don't get more time on that. You just get more time on that singular thing.
It did take a while to get the staging and
I
all
saw a
that
hand pop
done.
up somewhere else. Somebody else popped a hand up somewhere.
I didn't see one.
No? Questions?
I can keep asking.
Keep on going. We got 15 minutes.
So they like to say that the field adjuster doesn't have any authority. Is that true?
No. The insurance, if you look at your statute, anybody that would, this is why they don't want them to engage with us. If an insurance company representative would represent to you that something is true, then guess what? Becomes true. Who is an insurance representative?
Whoever they said no.
Anybody that comes out there, you're absolutely right. Correct, Shaun?
Yep.
See, now.
They're the authorized representative.
That's why they try to lock everything down. No, don't talk to those guys. Don't go. Shh,
And
don't
the
say.
same thing goes with us, if we send somebody else out that
It's what's good for the goose is good for the gander in every situation. You should always believe
It's
that.
respect
Yeah.
back and forth across the board. You can't be biased. It's not, I mean, they have IAs, and my best friend is an IA for Erie, QBE, and cross country. So, I mean, she works for them directly, staff, all that. They have to have a job. They have to have a profession, but it's respect back and forth. If you're taking an extended period of time to do something, give them the same leeway.
I agree.
Don't immediately rush to filing complaints and,
Well, if you sat on the
stomping your
files for
heels.
45 days because you were too busy to get to it,
I agree with that.
and then you got to it, you wrote the estimate, sent it to them, and then 2 days later they hadn't responded, so you start screaming and hollering about they hadn't responded after you waited 45, that's not a very reasonable stance.
Yeah, so
And
it's
I think
respect.
one thing I wanted to catch on from earlier, Shaun kept hitting on something that so many of us don't catch. This is bad faith. They can't do this. They waived their right. Okay, what you're talking about is something that only one person can decide. The judge. We don't get to decide that shit out in the field. And we should never have our process where it relies on what the judge should or should not do. We should have an absolute solid process that goes by what the known laws are. And if they fail at that, then to catch them at that. But we should never be running around believing that because, the contract's ambiguous, right? The judge is going to rule on behalf of the insured. Bro, you can't have anything to do with that. The judge is going to be the final determination of whether that contract was ambiguous and whether it goes towards the benefit of the insured. So when we make these broad statements out there that we are doing harm to the industry, we are doing harm to ourselves. No, the judge is the one that's going to make the decision. We should have our process modeled completely on what the known law is. Whether we like it, agree with it, or not, we must follow that procedure. If we want to get it changed, do what we're doing today. Get involved in the associations. Get involved in what you're doing. And key is to provide something for the boot camp for us. There's a couple of things that made us start the boot camp. Number one, Melanie and I were all alone when we started this. This is a very lonely place to be when you're all alone and the insurance companies have all of their minions coming after you. You're doing depot after depot. All of this shit is a horrible thing when you're by yourself. Number two, public adjusters weren't renewing their licenses. After 2017 legislature, they came in and they actually said, well, what are we going to do about the PAs this year in Texas? And they were like, we had less PAs renew their license. We had less PAs apply for new licenses. So evidently what we did is working. You understand what I said, right? That was the intent. No more new PAs, and the ones that are here quit renewing their license. We wanted to give you a place to where that didn't happen. In doing so, we now want to see reforms. The only way that we're going to see reforms is if we get to an apples and apples conversation versus an apple and an orange conversation. If you're writing estimates completely this way and you're performing claims completely this way, you're doing them this way and you're doing them that way and we're doing them another way, we don't have any product to bring to a legislative body and say, hey, this is absolutely what's going on, because we have people doing the same thing and we can see that we get the results the same way. So in other words, we're creating, for the first time, an industry standard for PAs. Every professional industry has an industry standard, doesn't it? And we don't want to be at the low end. We want the industry standard to be raised. We want everybody to go out, work a process, get something very close to what we have, what we provided, what we know damn good and well works. That way we can have a voice backed up with facts. This is what's really going on in the field. Doesn't matter what you say. Here's the facts of what goes down. You go out to every claim and you write the estimate, and yours is 1,000% more than the insurance company. As is yours, and as is yours, and as is mine. Right now it looks like we're the crazies. Till it goes to litigation, y'all end up paying fucking exactly what we put down there. For all of us, we all got to the same method there. Then we begin to show what?
Consistent.
The patterns that are necessary
Very
to get
methodical.
things changed. Bad faith. It's not on a single instance. Not because you messed up one time. No, it's a pattern of things that you did to get to that bad faith. We have to build that pattern and a general consensus within the industry of this is what a properly performed claim should look like. I believe we've done that.
And then Shaun can come in when necessary and pick it right back up. Got a synopsis of
Immediately.
everything you did because you documented it. It's not hearsay, it's business record. You want to keep out of depositions? Create business record.
Don't try to recreate the wheel. If you try to go back, if you do most of my complaints and things that I do when I'm doing them, I simply go to the log file. Copy, paste. Copy, paste. And the majority bulk of the complaint is done because it was done when? In real time, as this shit was happening, it was documented down. Yes, ma'am, go ahead.
What's better when filing a complaint, having the insurer do it or having the PA do it?
What?
You need to do it as, if you were the PA on the file, you need to do it. That, yeah,
What
your
was her question?
consumer's rights, is it better for the insured to file the
the PA to
complaint
file
or
or
the
the insured to
PA?
file?
But
I'll add to
be
that
aware-
state specific.
Be
yeah.
aware of the states, because in the state of Louisiana, you can't file complaints, although I do. But you can't file complaints on behalf, you can't negotiate, you can't argue, you can't do anything in the state of Louisiana, but that's what they hired you for, is for their consumer rights protection.
How would they know? And this is what pisses me off so bad about Louisiana. The person hired us because they don't know.
Yep.
How would they know how to file a complaint? How would they? If you take a typical complaint, even from PAs, what happened? That adjuster was a butthole. And he hadn't called me in a couple of weeks. Is that a valid complaint? No, that his demeanor, while being unprofessional, that's not really against the law. However, if he hasn't called within 30 days after you called him, or 15, depending on what state you're in, then he's actually broken the law, which is a complaint that you can file. Any complaint that you file must be attached to something where they actually broke the rule.
You have to
Prima
provide the
facie
evidence.
event. You did this. You had 15 days to finish this investigation. We're on day 16. Are you finished with the investigation? You're in trouble. Right? You agreed that when you said you were going to sell insurance in this state, that if any claims happened, that you were going to be able to go in and handle these claims within the time limits that the statute put out. If you didn't, then you got in trouble. Those change things. See, you have an asshole adjuster in the middle of this that has never been held accountable. They think they're God, and they go through this whole thing, and nobody above them really knows what's going on. And they never will until you file that complaint. When you file that complaint, we're like Oprah. Everybody gets a copy of the son of a bitch. Department of Insurance, your boss, their boss,
Well, and when you
the
submit
insured.
it, yeah, when you
But
submit
then
it.
somebody else gets a hold of it above this person's pay grade who may try to get the claim resolved, especially when they look and go, yes, this is a prima facie event. We are, in fact, right now in trouble because we have not done what we're supposed to do. What's your best recourse now? Let's try to get out of here.
And one good person that you need to copy also, which gets left out of the process a lot, is the insured.
First and
They
foremost.
need to know that you're filing the complaint. They need to know
And-
why
and
you're
that's
filing the
why-
And
complaint.
they love it. When they
Because-
see you elbow somebody in
Right.
the head, it's like a UFC fight. Yeah.
And that's where.
So they know before it goes
Yeah.
off, because they'll get asked in a deposition, were you aware a complaint got filed? Or why was this complaint filed, right? You want them, they're not gonna know all the technicalities that you know. But yeah, they need to know, hey, y'all weren't treating us right, you weren't getting back to us. Yeah, I was aware at the time that a complaint was being filed.
But as the PA, when you file it, you have to send it to 3 different people. First, the carrier and the adjuster always CC claims, never take them out. Travelers hate that you CC claims at travelersclaims.com. I'm not going to remove it because you might be reassigned today. You send it to the DOI, you send it to the carrier and the adjuster, and then you send it to the insured. When the insured sees it, never had a clue. I mean, you told them that you would take care of them and you told them that you would protect them. But when they see that you truly did protect them, you attach the evidence. You're not filing frivolous DOI complaints, because I do see that a lot. They file it and they're trying to get them to pay the claim. Like, no, that's not what the consumer's rights are there for. You're filing it, you're giving the evidence, you're giving all of the reasons, so hopefully the DOI can take action against their handling processes. And it does get audited based off of a certain amount of
You're getting it
complaints
on
you file
record.
within a year.
Yes.
So everything's a business record, everything is building. So if it goes to him, he can go hopefully above and beyond, because you might send 20,000 to him, you might send 150,000 to him. No matter what that number is, the insured is going to pay that, and us, because unless he gets it in court and gets the attorney's fees paid and settlements, the insured is responsible for those attorney's fees. So we have to do our job, and that's what the insured hired us for. That's also what the insured hired us for on that final demand. You're giving them a last-ditch effort to get it right. You already gave them a blueprint. Now I'm going to do your job again for you, and I'm going to give you a whole toolbox of all of this supporting evidence, which gives the exact reason of why, how, and what.
Let Shaun do the law.
Yeah.
Don't let him be an adjuster. Don't make him be an adjuster. Let any attorney that you're working with do what they're good at and what they have a license for, which is putting the law to what you've already done. What we're talking about is doing exactly that thing. You do your job, you put the process together, and you let the attorneys do attorney things, you let the PA do PA things, and the contractor do contractor things. Should be a really simple deal, and they've made it really gray. Mm-hmm. It's not gray. Policy puts it in black and white, the statute puts it in black and white, and the facts of the law are just that.
And the IA is
They're
going to
facts.
do whatever they want.
I work with multiple attorneys. Some attorneys that get the claim resolved relatively fast, and some that take a little longer, but the insured is indemnified even more.
That's what we're looking for. We're not looking for a specific timeline. We're looking for indemnity.
So
Yeah, that's what we want the ultimate goal to be, is that no more, but no less. And if indemnity includes attorney's fees, treble damages, and whatever may be going on, then that's exactly what we want to see, but you're not going to see that unless you do what? Your damn job.
So the
Yeah.
PA did the job. What are the key indicators that a public adjuster can either ask the firm and or
The law
verify-
firm?
The law firm.
Okay.
And or verify online that the attorney isn't just sitting on this, but they're actively moving it forward.
That's
Is there
a
no
Shawnee.
You can
Yeah.
email, well, I
So I
can
would say
email.
that the insured or
and
even the
ask for
public adjuster
updates.
can ask, has the pre-suit demand gone out?
Yeah.
Right? You know, we send a copy of that to our insureds when it goes out, right? Once the pre-suit demand's gone out and we give them 60 days notice, we're gonna calendar it to file it on day 61. Whether we actually do file on day 61 or not depends on the feedback we're getting from the carrier. If the carrier comes back and says, hey, we want to do a reinspection and we would like to sit down and discuss this, I'll give them some time to do that, a reasonable amount of time. But what you don't want to see is the pre-suit demand went out, day 61 is here, and that a law firm waited until day 180 to file a suit, right? Then you had an extra 120-day, 4-month delay for nothing. You may not have had a statute of limitations that was about to expire, so legally it's still a timely filed claim, but you just lost 4 months of momentum on that file. is what
But I
you
think
did.
what
And
you were
they gained
asking
enough
is, as a
interest and stuff
PA,
on
what
their
can
money
we
to
ask of
pay
the
the attorneys.
attorneys? My office reaches out to Shaun, and we'll give him a list, and we're like, hey, but he'll let me know, this one was abated, this one was removed to federal court, this one was this, you know, so you can reach
You
out
should have a good
repetitively.
relationship with anybody that you're putting this much trust into. And if they treat you as an aside, they don't want to give you the information that you're not called, and let me be clear, leave them alone.
Yeah, let them do
Let
their
them
job.
do their damn job. Don't be wearing the shit out of them. And if you have to worry about them that much, then you should not be referring claims
Yeah.
to them.
Yeah.
And we've worked with them. They're every attorney that's in this industry at some point or on, some at
Almost
very
everyone
high
in this
levels. Some
building.
worked one claim was like, you'll never get another. But you should have that relationship built with them where you know the people that you're referring to.
They're gonna
And then
take
you
care of
get
it.
client feedback. You should be getting client feedback throughout this whole process. That's how you get referrals. Referrals is our biggest source of business. We spend way more money on advertising for Public Adjuster Boot Camp than we do any other venture.
We don't advertise IBM.
Yeah, IBN is we go in and feed, but we spend very little cash going, hey, bring me a claim, bring me a claim. No, that comes from word of mouth. That
But
comes
when I move it to litigation and I get that process going, I'll let them know I'm your public adjuster. Me and you's got a relationship. Me and you have respect. You trust my work. You trust everything. So if he speaks and you can't understand what he's saying, or maybe you just don't like his tone that day, or you're in a bad mood and you just need me, you can always reach out to me. Now, I can reach out to him and say, hey, can you give her an update?
Yep.
But he's not going to reply to me because that breaks attorney-client privilege. But I will always, and I told him, until this is 100% done, I am your public adjuster, and you can always contact me, email me. I'll get your updates if you wish. I would rather them ultimately go straight to his office because my handling is over, but I'm their PA until he closes that
And
claim.
that's something that, a pet peeve of mine, just to protect the attorney-client privilege, right? Once the file's been transferred over and they have an attorney, right, whether they're in litigation or not at that point, any communication I have with my client is protected.
Yeah.
We don't have to turn that over. It's confidential, all of that. If, you send an email and you copy the insured on it, once we're already in that, litigation phase, it defeats attorney-client privilege, which means now I have to turn over all of those emails. So I've had some PAs, not too many, but some to send me an email, copy the insured on it, right? And just the way that email's written, I'm like, this is going to look really bad if I have to go turn this email over now. Do we have them by the balls on this one, right? Don't put that in the email and copy the client and send it to me, right? Now I'm turning it over to Allstate and saying, hey, here's
we got them by the balls.
right? And my response was no. But, so don't do that.
Just for clarity.
Just email me directly.
Don't do that.
Email me directly and I can give you an update. I can tell you what's going on.
Yeah, say, hey,
And
so-and-so reached out to our office. Can you please reach out to them?
Yeah, so
Whatever, and that's it.
I'll email the insured with the update. I'll say, thank you, Melanie. Yes, I'll reach out to the insured. I'll give them an update. And then I'll give Melanie an update saying, here's what's going on with the file.
But
I
you know
keep those
how
lines of
often-
communication separate once they sign up with us.
But it's been years since I've sent you, and I only did that because we moved offices. But
We
sent you
very
a
seldom ever
comprehensive
get an
list saying,
insured that
hey,
asks us where their
here's
claim is at
updates.
with Shaun, which is why we use this
Hardly
firm.
ever, yeah.
We've kissed a bunch of frogs out there. No, none of them turned into Prince except for old Shaun. No kidding. If you have insureds that are not upset with your attorney, they're not mad about fees, they're not calling you telling you they hadn't heard from them, they don't know what the hell's going on, where's this thing at, then you have a very good relationship with an attorney that's doing his damn job. We shouldn't, when I say we're done, we should be done. We shouldn't have to hold Shaun's hand, and if I'm having to hold Shaun's hand, and I have consumers that are consistently calling me, telling me they're unhappy, Shaun will never get another claim. Ultimately, is my name on there, right? I referred them to every part of this, and I want it to go as smooth as it did with us. I don't want our relationship to be tainted with what he's done. We have clients that we've done claims for 6, 7, 8 claims over a period of 20 years for the same client. We did all of their kids, we did their mom and dads, we did their business associates. It's the way the whole thing works. And if we don't do our job correctly, I lose that referral source. I don't want to lose my referral source. And I also don't want to be where we didn't finish our claim and you didn't refer me out because we didn't move fast enough. Or I overpromised you at the beginning. Man, we'll have this thing wrapped up right around the corner. No, this could take a while. Why? Because the insurance company would rather not pay. What we're going to do is we're going to give them every opportunity, and if they fail, then we're going to hold them accountable, and you have to be willing to do that up front. You have to know that that's going to be a possibility of theirs, is if they stop. It's why it's imperative to keep them involved at all times. Before the SPOL ever goes to the insurance company, the insured should sign that, get that document, and understand it. They get in a deposition, and the worst thing that could happen is they get in there and they go, well, did you know that your roofing guy that you had come out there, he wrote your estimate for a roof for $20,000? And they go, yeah. Cal's estimate is $48,000 for that roof. Do you think that's fair? And you see their face just blow up. What? $48,000? Okay, wait a minute. You didn't explain what the $48,000 was. Did that guy include OSHA? No. Did he include the decking? No. See, he didn't do all of these things, and his was a get you in the door price. But if the insured never understood that, they look shocked when they're asked this question, and now you look like a frickin' crook. And there's no way to redo this first impression on what's going on. However, if you kept the insured in the loop the whole time as you should, they signed off on that SPOL legitimately. They know exactly what you're doing and why, and that it is absolutely true and correct. Why did the roofer only write the $25,000? Because he doesn't do public adjusting, right? And he had every intention of doing what once he got that 25 grand?
Supplement.
Every time. Because they're afraid to write for true estimates. Well, what we want to do, and I think that's chicken shit. I don't think that you should ever be going to, I wouldn't want you to do it to me. Cal, you got this one shingle. Can you get this one shingle over here that we can get? Can you just please agree with me to do this one shingle? You know what? We'll give you that one shingle. Got it. Now we want the whole roof. You knew you were going to do this the whole time. Why didn't you start this way? Do you want to be treated how I just spoke? No. So you shouldn't be treating the insurance company that way. No matter what they've done bad. Doesn't matter. You're responsible for your side of the street and how you perform. Their dirtiness, their non-dirtiness, whatever, that has nothing to do with you. You do your thing, do your job, do your process. And what happens is that when you do that correctly, it shows how ineffective and inefficient and incompetent those folks are. The engineer gives you a 120-page report. You tear it up in a 2.5-page response that literally just annihilates it. It took you 120 pages to lie. It took me 2 pages to annihilate that lie. Completely, totally, and without question, and we didn't even really get into it. We just kind of skimmed on the things that are just so over the top that you can't deny. I think we're way over. Questions?
Only a couple minutes. Yeah, have questions, comments, concerns? There's a mousetrap at the door.
A what?
Mousetrap at the door. I always tell class that. You gotta go. You can't stay here, but if you got questions, comments, and concerns, there's a mousetrap, just put it on there.
She's funny. Ha
ha. Yeah.
I loves her. Okay.
I do not get paid for my humor.
Thank
That
you.
is for sure.
I do.
That's just free of charge.
Absolutely.
Figure out it.
Thank y'all for giving us your time.
We appreciate it.